Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305.
I don't think it will be. Hey, I'd like to call the our Monday morning Courts of Justice meeting to order. MJ, can you call the roll, please?
Here are my instructions. Mr. Chair, you have a quorum.
Thank you, MJ. Okay, we went to gavel in early so people can get their proxies in here. A few people that need to leave. First of all, I want to call up Senate Bill 931 by Senator Head. That bill needs to be, he wants to strike that bill. So Senator Deeds moves, Boyce goes seconds, that we strike the bill. Clerk will open the roll. Are you five for the day? Are you five for the day? On your still?
Yes.
Okay, and then,
Senator Obscene for Senator McDougal.
I'm sorry.
Ayes 14-0.
Okay, and secondly, thanks, MJ, that's stricken. Senate Bill 1158 by Obenshain, he would like that to go by for the day
Wednesday afternoon.
to Wednesday afternoon. All those in favor say aye. Aye. Anybody opposed? No. Okay, I think that's it for, easy stuff. So, Eben, is Eben up there? Okay, I don't see Eben. Eben is on the, is the only non-member we have in the queue.
Really?
Really. So, having said that, who would like to go first? Don't everybody step up at once. Bagby, you got a bill? Oh, yeah, you got a couple. You want to go, Bagby?
I would love to.
Okay, Bagby.
I would love it to do it from here.
Bagby, you have juvenile restraints, 1255, and you got 1261, which I think is a request from the state police, right? So, which one do you want to do first?
Okay, 1261.
Okay, 1261, this has juvenile fingerprints, right?
Yes, sir. Mr. Chair, thank you. SB 1261 amends the code to provide for the electronic submission of juvenile arrests, fingerprints to the Virginia State Police Central Criminal Records Exchange.
You have an
There's an
amendment?
amendment.
Okay, Senator Bagby has a line amendment, which should be in your packet. Senator Deeds moves, Boyce goes seconds to adopt the amendment. All those in favor say aye. 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 Is there anybody opposed? No.
Thank
So
you,
Bagby,
Mr.
what does your amendment do?
Thank you, Mr. Chair. This will reduce the errors and instances of arrests and convictions never being applied to criminal history records when the fingerprints are not sent to the Virginia State Police after conviction as required by current law. I know there is someone here from State Police that will want to speak on this, but this bill pretty much is just brings us up to what I feel up to date as it relates to how fingerprints are retained and making sure that we have an electronic copy instead of the now required paper copy that has caused some confusion throughout the process, particularly after or absent a conviction.
So your bill basically just brings juvenile fingerprints into the adult world where we do them digitally and not just on paper?
You said less with more.
Got it. Did we get that right?
Mr. Chairman, members of the committee, my name is Julia Gunderson with Virginia State Police. First of all, I want to thank.
Did I summarize the bill correctly?
Yes, you did, sir. Yes.
Okay. Does anybody have any questions for the state police? I don't think there's any questions about the bill. Is anybody opposed to the bill? I don't think there's anybody opposed to the bill either.
Move to report.
Okay, it's been moved and seconded, the bill be reported. Clerk will open the roll.
Senator Peake for Senator McDougal. Ayes 14-0.
Thanks, MJ. Bagby, next up you have 1255, which I think has to do with prohibiting restraints in court on juveniles. Is that right?
Yes, Mr. Chair. SB 1255 prohibits the use of restraints on juveniles appearing before the Juvenile and Domestic Relations Court unless certain circumstances before the court can order a juvenile to be restrained. The court must make written findings of the facts in support of the order. Virginia law currently allows indiscriminate shackling of children in court. Children are forced to appear weighted down by handcuffs, leg irons, and belly chains. They appear this way not because they pose a threat to others in the courtroom or are a flight risk. Instead, jurisdictions throughout the Commonwealth, just a few, shackle all youth in juvenile courts. And so, Mr. Chair, the goal of this is to remedy that challenge of jurisdictions abusing the ability to shackle children in courtrooms. And I want to make sure it's clear that an overwhelming amount of jurisdictions do not shackle at all, and some haven't shackled in years as it relates to juveniles. And so I know there's some individuals that will want to speak in opposition and in support of this legislation.
Thank you, Senator. I know that at least in some of the localities in Northern Virginia, there's one that will not stop shackling juveniles, even though the judges have asked them to stop, and they won't stop it. So I totally understand the need for this. Does anybody have any questions to the patron?
So you're for it?
I'm for it, yeah. Mr. Chairman. Senator Stewart has a question.
Just a quick question. Senator Bagby, reading this, does this require you to have a hearing before the day that they bring the individual in, or are you considering that they'll be back in lockup while you're having a hearing?
Mr. Chair, and then maybe somebody else can answer this question better, but from my understanding, it is the discretion of the judge.
Yes, Mr. Chairman, but I guess practical matter, you on these days, you typically will have people in lockup and they bring them in one at a time. Most of them now do video arraignments, but maybe not on the juveniles. I'm not in that court, but
Mr. Chairman.
I'm just wondering how it would work.
Mr. Chairman, I had a similar, I'm sorry.
You have the same question?
I had a similar question. I
Senator
was just
Perry.
thinking about the issue of an arraignment, right? That you're not going to have counsel appointed, so no one would know to file a motion. So I don't know procedurally how you would move through this.
Senator
You comment
Bagby,
on that, man.
Senator Bagby, you want Mr. Pogenglass to answer for you?
I'm waiting for him to come up.
Okay. Mr. Pogenglass.
Chairman, Rob Pogenglass, Executive Director of Justice for Virginia. We're open to suggestions like the Senator made on the procedure of this, whether, particularly with arraignment, if there needs to be an exclusion, whether somebody could be shackled at arraignment. But the overwhelming goal is that during the court proceedings, when the adjudication is happening, that the child not be shackled. So didn't want to make a categorical rule because not every jurisdiction has video capabilities. So that might be available in some communities, but not in others, as to whether the child could watch the proceeding to decide whether there was going to be shackling over video. That could happen in a lot of places, but maybe not everywhere.
Okay, anybody else have any questions for Senator Bagby?
Well, Mr.
Yeah,
Chairman,
Senator Perry.
I just don't know that we have come upon a solution to this. I support the bill. The bill sounds very reasonable to me. I just don't know, especially at arraignment. And to be honest, I'm not particularly inclined to say exclude arraignments altogether. That doesn't seem fair either. I just don't know procedurally how to get at if there's been no counsel appointed. And so I'm relying on the brain trust up on the dais here to come up with some better ideas.
Mr. Chairman,
Yes, Senator, I'm sorry, Mr. Benjamin, you had some feedback for that?
one possible solution might be on line 26, at the beginning of that first sentence, to insert where the juvenile is represented by an attorney, comma, the court shall provide the juvenile's attorney.
What does the committee think about that?
Where the juvenile is represented by an attorney, comma, the court shall provide the juvenile's attorney an opportunity to be heard. That would be on line 26.
The beginning of paragraph
So
B.
at the beginning of that sentence, you would insert those words.
Okay. Does anybody else have any thoughts about that? Anybody want to make that motion?
I move that we adopt the line amendment.
Senator Perry, does that address your concern?
I mean, not really, right? Because functionally speaking, right, at an arraignment, right, what happens in the morning, at least in Loudoun County, is juveniles are brought over to the courthouse. We don't do video arraignments for juveniles, and they're brought over, and then, the case is called, and then they walk out from the back. I couldn't tell you off the top of my head if they shackle every kid or not. I don't know how they fall. You probably do know. But let's presume they were one of those jurisdictions. And then in my jurisdiction, which is not true in every jurisdiction, the public defender comes in and represents the kid if it's a detention hearing. And so at that point, it seems to me this issue has sort of already occurred, if that makes any sense. And so I'm just not sure if maybe there is no way to get around the arraignment issue, particularly in these types of situations. But that is, I believe, what you are referring to, that type of scenario. Otherwise, kids come in from the public, it's really when you're being transported over from the detention center that you run into these types of issues. So certainly if there's an attorney, of course, they can make an motion under this, I would think under the statute, just as it's written, but.
The way I read the statute right now, basically says you can't use restraints unless the court orders them in a specific case. So if the Commonwealth, I guess, I don't think the sheriff has an attorney, but if the Commonwealth wants restraints imposed, they have to file a motion, there'd have to be an attorney involved in the case. So this would be no restraints unless it's asked for and a judge orders it. This changes the default, so in the arraignment, there wouldn't be any restraints, right?
That's right.
So I don't think this amendment, Mr. Benjamin, really addresses that scenario, right? And also this subsection D seems to assume there's an attorney involved anyway already, so it's not clear to me. Why don't we hear from the sheriffs, hear what the opponents are, and see what their concerns are? Because I'm not really clear what the concerns are here, because I don't see why restraints are necessary unless somebody has some risk or danger associated with them. We're talking about kids, and obviously some kids are big, but what are the sheriff's concerns about this? I assume you have concerns, you wouldn't be standing?
Yes, thank you, Mr. Chairman. Elizabeth Hobbs with the Virginia Sheriff's Association. We do have concerns. By Virginia code, the sheriff is responsible for courtroom security, from securing from violence and disruption. And they are also the experts who are trained in security, are trained in courtroom security specifically, go through, frankly, an enormous amount of training through DCGS to have that expertise. And so the burden shifting from the experts in the courtroom, who also have the particularized knowledge of somebody's criminal charges, of perhaps behavior during their period of detention, is supplanted by, or
Ms.
moved.
Hobbs, let me ask you this. The sheriff from Prince William puts restraints on everybody, whether they're at risk or not. I guess he's decided in his professional judgment that every child deserves, leg chains. Do you think that's something he was trained to do? Every single kid needs leg chains in a courtroom? You think that's part of their professional judgment?
I can't speak to that specific circumstance, but I do think there are considerations to be made, specifically that there's not a provision to fund even a single deputy per every JDR courtroom. So when you're looking at personnel, you're looking at the number of juveniles who may be put through a courtroom on a particular day. There are other considerations. And so rather than articulating a preference for a lack of restraint or standards to look at for whether there's a restraint, this particular bill shifts it entirely out of the purview of the sheriff and puts it in the purview of the judge, who may or may not have the access to the information or the particular circumstances for any individual juvenile.
Okay, I just know in the circuit I'm talking about, I've talked to the judges, they've asked the sheriff to stop doing it, he won't stop doing it. And so it seems to me that shifting the presumption and putting the burden on the sheriff to come ask might be a better way to do it from my point of view. But anybody else have any, were you done?
It can be.
Senator Stewart has a question.
I don't understand that. If a judge issues a court order that says you can't shackle juveniles in my courtroom, the sheriff has to abide by that.
Right, but this is
There's no question about that.
This is in individual cases, though, into the statute. Senator
Chair.
Bagby, you want to respond?
Mr. Chair, I think the purpose of this legislation and what this legislation has proven to do in other localities, because to be frank with you, other sheriffs in other localities are turned off by what's happening in about 4 localities and four or 5 localities in the Commonwealth. And what it happens is when this legislation is put in place, they stop doing it.
Mr. Chairman, I don't disagree. I don't disagree with Senator Bagby
And-
that it
yeah.
should be a rare case that you have to do that. I can tell you that there are cases when you may have to do that, but they should be very, very rare. Here's my concern. So what if you got 6 juveniles in lockup and they can't get anybody, a public defender, a court-appointed attorney, to help them go before the judge to have this hearing because the sheriff or the Commonwealth's attorney wants to make a motion to shackle them before they come in the courtroom? How long do they sit back and lock up? How many of these kids have to sit back and lock up all morning waiting to go through that? I'm not saying I disagree with your premise. I'm saying the mechanics of the bill don't work.
Yeah, Mr. Chair.
That's all I'm saying.
And I agree with you in that sense. That question posed by you and Senator Perry is a question I think needs to be addressed. And so what I would ask, Mr. Chair, is this bill go by for the moment.
Mr. Chairman.
Senator Perry.
If I can, and I apologize to Senator Bagby, I'm just spending some more time with the bill and thinking about it as we're sitting up here. I don't know what the members of the committee think, but I sort of think, the language here is relatively specific. It doesn't say, for instance, that you cannot transport a kid from the JDC over to the courthouse in shackles. It doesn't say that. This is limited very specifically to the kid appearing in the courtroom. And so it doesn't mean that child could not sit in the back in shackles. This just says prior to them appearing in court. And so I think functionally the way that this would work is that the Commonwealth attorneys there should be, the Commonwealth would have to make a motion. It does say the court has to make an affirmative finding that kid has to appear in shackles. So the Commonwealth should be the one who has to make the motion. Judge, we think this kid has to appear in shackles, and the court then makes a finding about whether or not that kid walks out of the back in shackles or not. I don't know what the members think about that idea, but I think procedurally that's how you might be able to move through this. And counsel, presuming there is counsel, can respond and be heard on that issue.
Mr. Chairman, it doesn't even require.
Mr. Benjamin, go ahead.
It doesn't even require a motion by the Commonwealth's attorney. The court on its own motion can advise the attorney that he wants the person shackled. So if a deputy comes out to the courtroom and says the next kid coming in is going to be trouble, then the court on its own can ask, is anybody representing this next juvenile? If so, provide the notice, have the hearing. And so there's no requirement that there be even a Commonwealth in the courtroom to make the motion. So I think it works.
Mr. Chairman,
Senator Perry.
I agree with Mr. Benjamin. I think if we put in the language, the Commonwealth or the court on its motion, but make clear this issue has to be addressed before that child crosses the threshold or whatever out into the courtroom. That decision has to be made by the court, or the Commonwealth has to make a motion for the decision to be made by the court. But Senator Stewart's giving me a face.
But Mr. Chairman, unless I missed Mr. Benjamin's amendment because I was talking about another bill, but
No, we didn't adopt it.
this says there has to be a finding, juvenile upon making a finding that. And if you don't have a hearing in order to make that finding, then there's a lack of due process of law for that juvenile. So I disagree with Mr. Benjamin if the deputy comes in and says this next kid's going to be trouble. All I'm suggesting is we need to figure out how it actually plays out. I don't disagree with the premise of the bill, but what I don't want, and I have been a Commonwealth's attorney in another life, and you want these kids to get an arraignment. You want them to get, or any kind of hearing that they need, bond hearing, whatever it is, and you don't want a bottleneck in the lockup. That's what I'm suggesting. If there aren't sufficient people to represent their interest, surely there's a way to draft the mechanics of it. I don't think the mechanics have it right now is all.
Bagby, are you still asking for a few minutes to go in the corner?
Send David to the corner.
All right, baby wants to go to the corner. Okay, so why don't you go to the corner with Mr. Pogenglass and Senator Stewart? I got two excellent. Yeah, they're two excellent ones, Pete. Okay, so to Bagby will go by temporarily, okay? Yep, I got it. Yeah, Eben's here. He has arrived. Okay, Senator Eben, why don't we take yours up? Senator Eben, you have one that we heard last year, which I think we have
could
some
start with
questions
that.
about, because we're waiting for Boyd Graves to speak, and then you had another one, which is
Senate
new.
Bill 1053.
Which one's that?
On synthetic media is a unanimous recommendation of the Joint Commission on Technology and Science. It targets synthetic media designed with fraudulent intent. It does not target synthetic media used for creative purposes. It just clarifies that synthetic media used for fraud is fraud, or slander, and that sort of thing.
So, Senator, this is what, you're amending a statute here has been touched since, I think, it was adopted in the 1840s.
Right.
So, which was adopted to prevent dueling. Why does who asked you to carry this? Why do they want to amend a statute that we've had on the books for over 250 or 150 years that nobody's thought needs to be
We
amended?
wanted to make it clear, like I said, that synthetic media used for defamation or fraud is just that. This is what Legislative Services prepared when we gave them that request. It's the unanimous recommendation of the Joint Commission on Technology and Science, and over the last year and a half, no one has come to me to express opposition.
Right, we gave it to Boyd Graves last year, though, and Boyd Graves.
They didn't review it. We asked them to review it, and they didn't review it.
They put it on their work plan, and they didn't have time to because of how late it came in. They got the letter, I think, in April or May, and they'd already developed their work plan. They were going to do it this year if they got it again.
The bill also directs the AG to create a work group to study and make recommendations on the use of deceptive audio and visual media, including deepfakes, by November. Yeah, and as I said, there's been no opposition brought to me, at least, about this bill.
Does anybody have any questions for Senator Eben about this bill? Anybody who litigates? Yeah, Senator Boysko.
Thank you, Mr. Chairman. Senator Eben, it appears to me that currently slander and libel statements are in the code as illegal. The way I'm reading this, we are bringing the code up to 21st century standards because there is so much going on online at this point.
Yeah, there was I don't think, Senator, that Mr. Chairman and Senator Boysko, that deepfakes were envisioned then, and just to clarify that.
Yeah. Thank you.
Counsel, Mr. Benjamin or Sabrina. Isn't it true that if somebody were to create an avatar, Scott Sorovel, which were then to speak defamatory words, that the person who created the avatar could be sued under current law for defamation for publishing it by creating the avatar and making that avatar speak, that's the equivalent of publishing like a newspaper or a piece of paper or putting it on the TV or anything else?
Nobody disagrees with the premise.
I could use your guys' brains on this. Use your brains on this.
Mr. Chair, I believe that's correct.
Right, so, again, I'm trying to figure out what new ground this plows, Senator. Other than, making clear what probably already is the law, so.
Like I've said several times, deepfakes, which you're familiar with, or synthetic media, that they too are covered, and that's what the bill does.
Right, the council just confirmed that you can already sue somebody for defamation if you create a deepfake that defames somebody. So, that's why I'm trying to understand what the need is. Why this is an ancient statute that we're amending that we haven't touched in a long time. No. Senator Robinson, you got a question?
So, so isn't, and I'm having a hard time looking at 801-45, trying to determine why Section A isn't already subsumed by the new Section B. Isn't it a lot of words to say the same thing that Section B says in a line and a half?
Section B is the important provision. If you want to change, otherwise that's fine.
Well, I'm wondering why mess with 801-45 at all? Because I think that synthetic digital content is subsumed by all words shall be actionable. Am I wrong? Anybody?
I don't think you are.
Mr. Chair, could I have Senator Obenshain repeat the question?
Yes. Section A of 80145, and I salute the draftsmanship, but isn't that a lot of words to say the same thing as the existing line and a half that constitutes 80145? I mean, isn't synthetic digital content, aren't those words?
Mr. Chair, if I'm understanding the question correctly, the definition beginning on line 17 of synthetic digital content includes audio, image, and video, aside from just text. So I believe it's expanding it, if my read is correct.
Counsel, what the bill does is two things. It creates, number one, it sort of messes around with defamation, and number two, it creates a new crime, right?
So, but
And the synthetic media definition, unless we amend it, put the definition in 18.2 doesn't apply to anything in 18.2, right?
And doesn't, I mean, to the
Senator
extent that you're saying that it somehow now subsumes images, I mean, we're potentially dramatically changing 80145, the action for insulting words, if that's the case. And I didn't read it as a dramatic change. I just read it as a restatement of what words are, and maybe a redefinition of words that may not include words.
Mr. Chair.
Senator Boysko?
Thank you, Mr. Chair. The way I read, I mean, seeing something in words that is untrue is one thing, but seeing your face and your likeness and your voice emitting those words is something different. And I think it does need to be addressed. I don't know if this is the right way to do it.
I don't think this is that.
But this also sets up a work group to study and make recommendations on the enforcement of the laws using digital content to continue to try to perfect this policy, which I think is needed. I mean, any of us who have had experiences where someone...
So,
Senator Obenshain?
does it take into account parody? Or does it criminalize parody? Only, Mr. Chairman, if it's used in the commission of a crime.
Senator, I think part of the reason you're seeing a lot of baffled expressions is this is why we send these things to Boyd Graves. They have a lot of really smart lawyers that look at.
Yeah, they
things and
didn't
spend a lot
act
of
on
time.
it, and we asked them to act on it before this legislative session. You know, I mean, I prefer the bill pass, but if you want to just have the work group portion, that would be one approach.
And I think maybe that's a good idea. I think that, you know, in terms of the 18.2 to 13.3, you know, we've spent a lot of time over the past couple of years talking about piling on additional offenses. That is what this does, is it adds an additional offense that can be charged in conjunction with the fraud. So
It's a significant problem, these deepfakes and synthetic media, that is worthy of an additional offense, or, in my opinion.
well, if adding offenses is the solution, then I've got a lot of other bills that we can talk about. But
This is one that's not.
I know.
Senator Favol, is your light on for a reason?
Yeah, I was just going to make a recommendation if that's in order. Did you say go ahead?
Yeah, do you have you have a thought?
Well, Mr. Chairman, since one of the enactment clauses does have the Attorney General convening a work group to study and make recommendations on the enforcement, couldn't you just expand that work group a bit to be talking about definitions of digital and other types of offensive images. You could expand in other words, my suggestion is you could expand what this work group is already charged.
Are you suggesting that we add a reenactment clause to the bill and with regard to section 1 and then have the work group look at this stuff in the interim?
That would work too. You've got some of the language already here, so if you can figure out that language now, that would be good. Otherwise, could we pass this in concept? Or do you want?
So sorry, Senator Full, what did you want to add besides deepfakes? Were you saying there were other types of things you wanted them to look at, Senator Favola?
I would like to look at the items that Senator Eben brought up in lines 17 through 23.
17 through 23. That's a deepfake, right? Right, Senator Evans?
Yes, yes, synthetic digital content or deepfakes. I think it's in the work group. It says related to the use of synthetic.
It does. So I think, consistent with what I said, if we just put a reenactment clause on that section 1, then section 2, you could have your work group with the Attorney General looking at this in the next 12 months.
That would be great.
Okay. So I think Senator Favola moves and Senator Salim seconds that we add a reenactment clause for section 1. Sabrina, you got that? Okay, all those in favor say aye. Aye. Anybody opposed to that? Okay. Anybody have any other questions? What's now work group, Bill? No? Okay, move to report a bill, and Senator Deeds will second that. Sorry, is anybody opposed out there?
Any attendees online that would like to speak in opposition, please raise your hand.
Okay, clerk will open the roll.
Ayes 10, noes 5.
It's a work group now. You can change your vote. Just tell, yeah, it's a work group. It's just a work group, Bill, now. Just tell him. We have to reconsider it. Huh? Yeah, reopen it. Let's vote it again. It's just a work group.
Thank you, sorry.
Okay.
Ayes 15, no 0.
All right, bill reports unanimously. Senator Evan, you had one more, I think.
Yes, SB 1060 has an amendment in the nature of a substitute.
Okay, Senator Deeds moves and Boyce goes seconds. We adopt the substitute. All those in favor say aye. Aye. Anybody opposed? No. Senator, you've got, so now you have this bill about hemp and tobacco. What do you expect
This
to-
is about tobacco and nicotine, retail tobacco products and hemp products intended for use by people under 21. The most important thing the bill does is it gives people the right to confiscate those products if someone under 21 has them. That was mistakenly a change made last year when we dealt with this topic. It also makes some technical fixes for interagency cooperation in enforcement and dealing with dealers who, retailers who sell to someone under 21. They're mostly about the agencies working with each other. They're not, don't dramatically change what we passed last year.
Okay, Senator Boyce is going to take over while I go present in resources where Senator Deeds is hiding.
I'm not sure, did you all adopt the substitute? Has it been?
I don't believe we did. Did we adopt? We did. We did, okay.
Okay.
Thank you. So, did you bring anyone here to testify on the bill, or?
Oh, I do have a witness, yes.
Okay, thank you. Please. We have a substitute. It's in the packet.
It's in the packet.
Thank you.
Madam Chair,
Yes,
may I ask a question first?
Senator.
Because they may answer my question for me. So this prohibits makes it illegal for people under 21 to possess these products and use these products, but possession is specifically what I'm thinking of. So, and I go to the military. If you're on a base, federal law preempts state law, but they actually are guilty of possession if they drive off the base. Is that accurate?
I'm told that military members are not supposed to be possessing tobacco under 21. We heard that last year,
Is
but
that
I'm not.
federal?
I'm not certain of that. But that's what someone said last year, that you're not supposed to be in possession when you're under 21. But I'm not. I can't attest that because I haven't looked at that myself.
Mr. Benjamin, I don't want to put them in a trap where they think they can do it because they're in the military on a base, but then when they drive off base to housing or something,
We have someone who
subject
can
to
clarify that.
Huh?
We have a witness who can clarify that.
Okay.
Madam Chair and Senator Stewart, Dylan Bishop on behalf of the Virginia Smoke-Free Association. There is a federal law that prohibits possession of nicotine products under the age of 21 as well. That was passed, I believe, in 2020 and then amended in the last 2 years to do away with the military exemption. Yes, sir.
So the changes in the bill removes the reference to attempt to purchase or purchase, includes 15.2-912.4 to reflect necessary technical amendments to cross-reference, makes changes to subsections B, C, D of new 18.2-371.2 on lines 35 and 42. Subsection B provides for a clear seizure and destruction of process of possession. There is no longer an education component for the second or subsequent offense.
That was unenforceable. We don't have a way to keep a record of that.
Okay. Are there other questions of the committee? Peak. Senator Peak.
Senator Evan, can you simply restate what what you're trying to do here?
Sure. We're trying to make it simple for any retail tobacco product or hemp product not intended for smoking, purchased or possessed in violation of the section to be deemed as contraband and confiscatable. So you can take them away from a minor if you find them with a minor.
Madam Chair.
Senator Peak.
So, Mr. Evans, without these, what's the status of the law? We
heard from some Commonwealth's attorneys that after the change we made last year, that there was difficulty in confiscating from minors.
Okay, because,
That's
Madam Chair, so this is part of what I would say negligently allowed to happen. Last year, we took it out of any kind of criminal penalties, especially in high school, so they couldn't enforce possession of it at all. And so what this allows, it at least allows them to take it as contraband and destroy it.
It's the law. Our current code elsewhere says that all student codes of conduct have to prohibit the possession of products on school grounds and school activities. We want to make it clear that it can be confiscated.
And now, Madam Chair, so now it can be confiscated. And I believe, Madam Chair, there's another bill by Senator French to actually make it criminal again.
He's got penalties, significant penalties.
Thank you.
And for tobacco as well, I believe, Madam Chair. Anyway, thank you. You were trying to clean up a mess that we made last session.
Yes.
Thank you.
Thank you. Are there other questions of the committee? Anyone else in support of the bill?
Any attendees that would like to speak online in support, please raise your hand now.
Madam Chair, Dylan Bishop on behalf of the Virginia Smoke-Free Association. We thank the patron and support the legislation. Thank you.
Thank you. Is there anyone here in opposition to the bill?
Any attendees online in opposition that would like to speak, please raise your hand.
I apologize, I was not quick enough to get her support, but Elizabeth Hobbs with the Virginia Sheriff's Association, and we do support the bill.
Thank you.
Madam Chair, members of the committee, Gonzalo Ida with the American Heart Association. We're not necessarily opposed. We just have some concerns about reintroducing any kind of penalty on minors for possession. But we do understand the intent of the patron, and these are concerns we express for the House version as well. So thank you.
Thank you. I have a question of the patron. Is there an additional penalty or any criminalization of this, Bill?
No, it's not a criminal penalty. We just want to take the tobacco away and let the schools deal with it if they
Thank you
want
for-
to impose anything else.
Thank you for the clarification. Right. Comments from
Madam Chair,
Senator
I move we
Deeds?
report and refer to finance.
Thank you. Is there a second?
Just a quick question.
Senator Peake.
Association. Why do y'all why does the Heart Association have a concern about taking away contraband tobacco?
Yes, sir. Madam Chair, members of the committee, I'll clarify further. We don't have an issue with the actual confiscation. We just have concerns about the potential of introducing a situation where law enforcement and children will just increase interaction unnecessarily.
This is necessary.
Madam Chair?
Thank you. Thank you for the clarification. As the patron just stated, this does not add a criminal penalty. So we have a motion and a second that this bill as amended be re-reported to finance. If the clerk would open the roll.
Senator Servo leave a proxy?
He did
Servo
not.
did not leave a
Okay.
I'll get his
proxy.
vote when he gets back, Madam Chair. Ayes 14, no zero.
Thank you.
Thank you, Madam Chair.
Thank you, Senator. I'm going to let my colleague, Senator Deeds, take the gavel.
And I think Senator French is next.
Good morning, committee and Chairman Deeds, I guess now. I got 3 bills. I'm going to switch my order a little bit to do my bills that kind of pertain to the last topic that we were on. And the first one I have here today, I'm here to introduce Senate Bill 1146.
1146.
And I
turn your
have a
attention,
substitute of the
Senator
bill, which clerks have.
Got a substitute. Do I have a motion on the substitute? Senator, okay, motion and a second. We adopt the substitute. All in favor, say aye. Okay, the substitute's before you. It's in the packet, I assume.
So basically, this bill, I've been working with some of my school boards and SOR officers, and what they're wanting is, right now, if we're going to change the fact that if a kid gets caught with tobacco or vape in their possession or in use, they currently get a $25 civil fine. And what we want to do is change that to the first time, a $25 civil fine, and their parents or guardian must be with them to pay that and do that. And then each time after that, the second offense would be $100. The third offense would be $300 with the parent or guardian be there for restitution. And this also, of kids of over 18, they do not have to have their parent or guardian with them for it. So this is just to help our public schools try to get control of these things that we know are unhealthy and causing harm to them, plus making our teachers and our resources trying to help get a control on it. So that's legit of it. And I do have someone, a sheriff from one of my counties, that is going to attempt to talk online.
He's online.
Yeah, he's online.
What's the name?
Travis something.
Travis Sumption, you may now speak.
Morning, committee. My name is Travis Sumption, the sheriff of Clark County, and I thank Senator French for helping out with this bill. I'll make my points brief here. Vaping is an issue within the schools. It's not so much as the vaping itself, but it's the disruption it causes in the schools. We're dealing with, vapes. We have no idea what chemical it is. So we're dealing with a lot of issues of vaping in school. But one of the things that really hit me home with me last year when my kids were in high school was it got so bad where we took a high school here in Clark County and only had one bathroom operating because everybody was destroying the bathrooms because every time somebody comes in, you're flushing the vapes down the commodes, clogging up sewage drains. There's not enough administrators to wash the bathrooms. And so it became an issue with my son personally, where he just didn't, he just felt very uncomfortable. He wouldn't use the bathroom because there was a long line. So it comes down to, we're not looking to criminalize anything. I think juveniles should be, be more handled differently. But it just comes to a point where we don't know what these chemicals are in the vape, and the vapes themselves are causing more issues with behavior, with people trying to hide the vapes, flushing the vapes, hide the vapes up in the ceilings. We're having stuff torn apart in our schools. So we really want to try to get a hold of this and give an extra tool to eliminate the problems that we're having in our schools.
Okay, thank you, Sheriff. Is there anybody else who would like to speak in favor of this bill?
Any attendees online in support that would like to speak, please raise your hand now.
Elizabeth Hobbs, Virginia Sheriff's Association. We support this bill as well.
Okay, thank you. Okay, is there anybody opposed to the bill?
Any attendees online in opposition that would like to speak, please raise your hand.
Mr. Chair, members of the committee, Gonzalo White again with the American Heart Association, and we are opposed to any monetary penalties on this issue. Thank you.
You're opposed to the monetary penalties?
Yes, sir. Yes, sir.
Okay, thank you. Okay, I just looked at Senator Servel's notes. Does the substitute take care of the work group's issues?
Mr. Chair, I believe so, yes.
Okay, thank you.
Mr. Chairman,
Senator Kilfoy.
question for the patron.
Oh, no.
Senator French, quick question. I see that it requires a plan of community service in the bill. Who would be overseeing the community service requirement?
We feel sure by this point it'll be in front of the judge, and that will be implemented by them if they deem that that's after they've, heard the situation. The overall goal of this bill is to get the parents involved, because currently they do not need to be involved, but any type of community service or anything like that would have to go through the courts.
Okay. So otherwise, Mr. Chairman? So
Sorry.
besides the fine, then there is the complete a plan for community service work, and that you're saying that both of those things will be overseen by the judge. Is that correct?
Judge in the courts, yes.
Mr. Chairman?
Senator Kilfoy.
Senator French, would you find it a friendly amendment to strike the community service requirement? My concern is that because this is a civil penalty, they're not entitled to any type of court-appointed representation. So who would be, and the judge can't give any type of legal advice, so who would be responsible for helping this child or explain to this underage person where they can complete community service, the requirements, that it has to be on letterhead, signed by an individual, and that is something that'll be acceptable to the court. So my concern is because they're not entitled to court order representation, there will be no one to really guide this underage person in the logistics of completing the community service work. So would you find it a friendly amendment to strike the community service piece and keep it as a fine?
Yes, I think it would. We're still with the parents there and the fine increasing, and I think that's our goal, is to get our guardians and our parents involved in this situation instead of just letting the individual youth pay $25 each time.
Mr. Chairman, I have a motion. I have a motion to strike the language regarding shall also complete a plan of community service work.
Second.
So you want to strike everything on lines, I think it's 71 through 72, in addition through, oh, I'm sorry, I don't know what this is about. Okay. I think Senator Deeds took my substitute packet.
Yes, Mr. Chairman, for Senator Stewart, to strike the language requiring the community service work, the plan for community service work. And the challenge is because it's a civil fine, that they're not entitled to court-appointed representation or attorney. So there's really no one there to help guide this underage person on the logistics of how, when, to complete the community service, because there's certain community service courts will accept and some they will not. So just to keep it clean, if the idea is just to have a civil fine, then I think the community service is superfluous.
Okay, it's been moved.
Speaking to that?
Go ahead, Senator Stewart.
I think we should do the opposite. I think we should strike the fines and give them community service. I work in, rural Virginia, and these folks don't have a lot of money to pay fines with. And one of the things I learned when I was a Commonwealth's attorney, I didn't want to send kids to juvenile detention because I just didn't think it was good for them. So kids who did stupid crimes, I made them pick up trash on the side of the road, and 1 hour equated to a mile, and they didn't want to do that again. So I think community service is much more effective than the fine, but it's just me.
Okay, does anybody else have any thoughts? Senator Boysko?
Mr. Chair, I have a question for Senator Stewart. How would we make that happen if it's not going to go through the courts then? Because I think Senator Carol Foy's point was well taken.
The court would determine the community service. They'd say you've got to do an hour, you've got to do 2 hours. But what I did, I made it simple, and my policy was you have to pick up trash on Route 3. And their buddies saw them, and it was a fate worse than death. And if you had an hour of community service, that equated to 1 mile of road. And it was easy. It was easy.
Senator Serval.
Yeah, French, then Perry.
Is there a way that we could allow the judge to determine if he, it's the first time, either or, put it back in the communities for them to work with?
It could. Senator Perry, something you want to say?
Yeah, I did. We don't usually fine juveniles, right? We had bills about that last year. We don't usually do it because who ends up paying the fine? It's not often the kid. Hold on just a second, Senator French. I'll say whenever I read this bill, community service is fine. To me, the point is to educate kids on the use of tobacco and nicotine. And juveniles, we use all kinds of interesting things to help juveniles understand the consequences of their behavior. So outside of the community service, the thing that struck me the most when I read your bill was we should make them write a paper on the dangers of nicotine and smoking and the potential impacts to their health and have them turn it into the court. That's also something that they probably won't enjoy and is probably beneficial to them and really gets to the onus of, hey, this isn't actually good for you. And that's the point of it. I'm not suggesting it is the solution, but it is a solution, and it's what occurred to me, and it's exactly the kind of thing we often do to help juveniles in juvenile court. It is all about rehabilitation and education.
I think we all understand what we're working with here. We're just trying the best way to enforce it.
Brent, you want to go by for the day so you can go talk with Stuart Perry and Carol Foy, maybe in the floor or something, try and figure out if there's some kind of consensus you all can reach instead of us doing it in front of everybody?
I agree with that. Yep.
Okay, Bill, go by for the day. French, is that your only bill?
Yes.
That's it?
Chairman, I have Senate Bill 1145.
We have another one? Okay, hold on. Oh, this is the GPS one.
Oh,
no.
No, sorry, wait a minute. I don't want to do that first. Excuse me. I'm sorry.
You want to do GPS first?
No, I wanted to finish with my tobacco and vape. This is Senate Bill 1147. Senate Bill 1147. And we have a substitute. It clears up a minor conflict with this one.
Okay, hold on. Let's see, 1147. Got it right here. Okay, Senator Stewart moves. Peak seconds, we adopt substitute. All those in favor say aye. Aye. Anybody opposed? No. Substitute is before us.
So
Yeah.
basically here what we're trying to do is just help this overall situation. I think we all have seen, more vape shops showing up in our communities, and we're just trying to make sure that we have them responsible for looking out for our minors. So this
Senator,
bill-
you're increasing the fines on vape shops, and you're requiring a mandatory license suspension for the unauthorized sale of tobacco products upon multiple violations?
Yes. So we're going from 500 to 1,000 to try to make sure they're doing the proper thing the first time. And then if more than 4 times in 3 years, they'll lose their license indefinitely.
Got it. Okay. Anybody have any questions for Senator French? Okay. Is anybody opposed to the bill? Convenience store owners that like to sell illegally to kids? No? Okay.
Weak on crime, though.
Weak on crime?
I think this is a bit weak.
Okay. Okay, this bill also needs to go to finance. I think I heard somebody make a motion. Is there one?
Move to report and read first and final.
Okay, it's been moved and seconded. We can send this to finance. Clerk will open the roll.
Ayes 15, no zero.
All right, French, you're off to finance. 11:45. We haven't done that yet, right?
All right. Yeah, thank you, Chairman Servo. And Harold, from a third bill today, we have a bill 1145. In this bill, we basically we're making it anyone who drives on a private road labeled for non-trespassing, and this is not a GPS route and all that. It clearly is labeled, and there's definition within our state code that says what that has to be. That person, if charged with trespassing, can then go to the GPS provider that put them on. Excuse me? Oh, I thought I said that. I have a substitute for this
Okay.
bill.
Stewart moves, Peak seconds. We adopt substitute. All those in favor say aye. Aye. Anybody opposed? Nope.
And the purpose of the substitute is just to make sure it's someone within a vehicle, not someone walking or something like that. So what's happening out here in rural Virginia is mainly we find there's some kind of software that's putting delivery drivers on private roads. And we've asked, and people have asked in all different counties, and I've talked to other rural legislators, they've asked to get off this software, and they can't do it. So we're trying to make it somehow where people quit speeding through private roads because people feel like it's their land. They've allowed their kids to get out there and use their bicycles or whatever on their private maintained roads, and it's a big problem out here. So we're just trying somehow or another to try to tie the GPS provider that's told an individual to use this route to get that route off that software.
Mr. Chairman.
Yes, Senator Stewart.
I like this bill, and what he's doing is essentially adding the GPS company as a party to the trespass. I think Section A is a restatement of the law as it currently exists, but you can't get any relief. And I have this situation, and others have this situation, and it happens all the time. I would, though, it's kind of scary to add a corporation as to a criminal offense. And
It's a civil infraction. It's not even an infraction, it's a cause of action for trespass.
Well, okay. Maybe you want to think about adding an amendment to the end of Section B that says, if the company removes that road from their list, they're released as a party. And so then you get enough, but because they just won't do it. I mean, you can try to contact somebody and get them to take it off their mapping system, but they just won't do it. I have this problem a lot. And that would give you some mechanism to get them to remove that. And I don't want to say a name, but we all know which one it is, Earth. And they show that stuff, and people think it's okay to use it when you can't. I would just suggest that if you remove it from the website or whatever you want to call it, you are then released as a party to the action. You like that? A guy like Saki likes that. Okay.
There's supposed to be.
Do you have language for that or no?
Well, I think I just said it.
We can verbalize some words, yeah, I know.
I just said it.
Mr.
Counsel,
Chairman,
some of you guys-
Mr. Chairman, Senator Stewart, do you want to make it an affirmative defense?
That was an amendment.
If you wanted to make it an affirmative defense, you could add subsection C saying it shall be an affirmative defense if, what you said.
They remove it from the posting or whatever. Yeah, however you think it's best.
Mr. Chair.
I think we should give them that out.
My only question is the mechanism, Mr. Chairman.
Yeah, Senator Peake.
It seems like failure to have an inspected vehicle. They always dismiss it complied. And so if they can show in court that they have removed it from the site, shall be dismissed complied, but they all still have to pay court costs.
Mr. Chairman.
like the
Yeah.
I
inspection
don't want them
sticker.
having to go to court in every county in rural Virginia. That's kind of tough. If they can just show evidence that they have, that's all anybody wants. They just want it taken off, so people will stop doing it. I defer to staff or Mr. Benjamin as the easiest way to.
Then,
make
Mr.
that
Chairman, Senator Stewart, perhaps something saying upon a showing in whatever form that, good.
Upon a showing by such company in subsection B that the road has been removed from the vehicle navigation or mapping system, the matter may be dismissed or shall be dismissed as to such company.
Mr. Chairman,
Yep, who's that? Perry.
if I could just add that just to be clear on your language there, that they can provide that proof in writing to the court to alleviate Senator Stewart's point that they don't have to show up at every single court hearing. I think it's just as helpful, hey, they can put it in the file.
Okay, so upon a showing by such company in writing, or such company in subsection B in writing, that such road has been removed from the vehicle navigation or mapping system, such matter should be dismissed as to such company.
Such proof can be provided prior to court. Something along those lines, because in writing, when you just add the words in writing, to be totally fair, they may think they have to show up in court with some notarized piece of paper to present to the court, and I'm trying to prevent that happening.
So in writing.
Mr. Chairman, if you want to be very broad, you just say in whatever form, upon a showing in whatever form. So it could be a telephone call, it could be,
I think Senator Perry was looking for something that can be documented and put in a file.
I think that'd probably be helpful if there's a subsequent violation, or if it's not removed, is I think we're part of the issue, but I would just say that, I would just include the language that they can provide it prior to court.
Yeah, Mr. Chair, I think at the beginning of the sentence, we could say prior to any hearing or any proceeding or any hearing in the action and upon a showing by such company.
Okay. Are we good? Okay, it's been moved and seconded. We adopt that amendment. All those in favor say aye. Aye. Anybody opposed? No. Okay. Hold on. Is there anybody opposed to the bill? Google, you out there?
Any attendees online?
Oh, Google's
in
here.
opposi-
I have dealt with Mr. Rowling on GPS mapping issues in my own district, so I was surprised he wasn't here. He appears. Okay.
Thank you, Mr. Chairman and members of the committee. My name is Guy Rowling. I'm with Albertson Company, and we represent Google. When I had the opportunity to first see this bill, I was applauding the sponsor because we've never seen anything like this before in the country, I don't think. And I just wanted to point out, and I think this maybe alludes to what you said, Senator Stewart, we do have an app. Google has an app where the property owner can notify Google using their app to add or fix a road. So you can report that this is a private road, and it will be reflected in Google Maps. So that doesn't necessarily mean that somebody's not going to still, drive on a private road, but it will be reported and listed as a private road. The other thing that we talked about was, it was kind of, we don't understand what the owner or operator of such a GPS, what does that mean? Because we use a lot of third parties to provide the underlying road data.
Mr. Chair.
Senator Boyce, go.
Thank you. Mr. Chair, there are some places in Northern Virginia where people don't use internet. Either they still don't have internet access, or perhaps they're elderly, or just don't have the capacity to figure this all out. It shouldn't be incumbent upon them to be responsible for somebody else's mistake, right?
Well, my point was, they know whether the road they're on is private or not. And that the best way of making that appear on an app is for them to report it.
Mr. Chair, I
Senator
I understand that, but I'm just saying that there are certain instances, especially in rural Virginia, where that's just not going to be a possibility for those individuals. I just wanted to make that clear.
And Mr. Rowling, your second concern was removed from the substitute. the such owner of the GPS. That's no longer in the bill.
Okay.
Okay, so I understand Google says you have a function. Is it not clear? Is Google have a position on the bill other than just general feedback?
Yes, I mean, I just wanted to point out to the committee that we do have a fix for that.
Okay, which is a lot cheaper than a lawsuit if somebody wants to do it. This is kind of suspenders on the Google belt. Yeah, Senator French, something you want to add?
Just one, since I'm here with all you great minds, and I'm just an old farm boy out here trying to keep our kids and stuff safe on our rural or our own roads, what happens to the individual who I charged with trespassing for disobeying my signs? This is not a GPS. And he relied on someone else to, or she relied on someone else to tell them to take that road. And to respond to what a lot of my constituents have tried to take the steps to get these roads off the map, and it's not easy, and it doesn't happen when they think it's going to. That's just, that's what we were.
Okay, sorry. Who are you?
Good morning.
Support opposition?
We support it. Virginia's mounted fox hunters and beagle foot packs. Private property is important. We have to support it.
Okay, fox hunters support it. Okay, does anybody else oppose the bill besides Google, who sort of has feedback? It's not clear whether they oppose it or not. Anybody else? No? Okay, what do we want to do with this, guys? Okay, it's been moved and seconded that we report the bill. Clerk will open the roll. Substitute, yeah, substitute is amended, yep.
Ayes 15, no zero.
Thank you, committee.
Yeah. All right, no other non-committee members are here right now. Not sure we have any others left. I know Peak has a couple, Stewart has a couple, I got an easy one. Peak, you want to go?
Mr. Chairman.
Did you fix yours?
Yeah. Senator.
I think Senator Bagby is ready for his bill to be reheard. I think we have.
Okay, we'll come back to him after
fix,
Peak.
whenever
Peak
we have a
knocks his
second.
out.
All right, Mr. Chairman, members of the committee, let's
67.
start with 1069.
Okay, 1069.
But before we adopt the substitute, let me make a little statement on this one. The current bill is for retired judges. By code, they have to attend the judicial conference every year, and it's mandatory for them to be able to continue sitting as retired substitute judges, but they are not compensated for attending the judicial conference. That is a very simple part of the original bill. We have someone from OES who is here who would testify that they support that, and that it costs about $300,000 a year. We have a potential amendment brought about by the 41st Senator, Mr. Benjamin, and I agree, and anybody who is a lawyer, trial lawyer, has a retired judge. Usually it's a retired judge because it's a complicated matter or there's some kind of a conflict. And circuit court, talking about circuit court. And this really would only apply in circuit court or a couple of complicated matters in general district, some boundary disputes, some things that I've had. But what happens is you show up in court, everybody's briefed the issue, they've written extensive legal briefs, memos, etc. They send them to the retired judge. The judge shows up in court and says, I have not read your memos, I have not read your briefs, I have not done any preparation, but I will hear while you're sitting and waiting because the Supreme Court does not pay me other than the day that I am actually sitting. And that happens frequently. And so the amendment to the bill would allow for compensation at some rate for the judges to read briefs, to read memos, so that they can prepare for their actual appearance in court. Now, I've talked with OES about that. We do not have an estimate for that cost at this point. I think the first part's fairly uncontroversial.
And we just doubled their per diem 2 years ago, you remember, right?
But they're not getting it. The retired judges are not getting any.
We doubled the retired judges per diem 2 years ago from $200 to $400 a
Oh,
day.
yes, for the second part. So what my proposal to the committee would be that we pass the original bill and then do a letter to OES or Supreme Court or whoever it would be regarding some kind of an hourly rate for preparation to avoid dead time, which is a waste of court's time, when the judges show up and then begin reading briefs and memos.
Okay, so we have not adopted your sub, right?
That's correct.
And you want us to not adopt your sub, but maybe to adopt what, enactment clause?
To do an enactment clause, whatever. I'm up to the committee or council as to how best proceed on that second part to consider compensation for judges for preparation.
Okay.
But I think the first part, the original bill, should go through.
Okay. So you want an enactment clause that basically says that, who, OES?
OES.
OES shall study whether judges should receive compensation for preparation.
For reviewing memos and briefs that have been submitted by parties.
Okay. Sabrina, you got that? Okay. Senator Stewart moves prior to the hearing. Senator Stewart moves, well, they might have to write an opinion too.
What?
You might have to write an opinion.
That's right. In preparation, just in preparation for and.
Well, how do you say that? You don't mean during the day of hearing. I mean, the problem is they come in and say, I haven't been able to look at any of this because they don't pay.
Right, Senator, but I know there's some very complicated, for example, I know Judge Schell had to do the Arlington missing middle zoning thing and came back and issued a long oral opinion on that afterwards. But I'm just saying, like, there's stuff that happens after court as well, not just prior to court. But,
Mr. Chairman, what we had suggested was that judges be paid an hourly rate as determined by the Office of the Executive Secretary for any time necessarily expended in the discharge of such service when not actually sitting.
There you go. That's why.
right. So we're just going to have OES look at that, not pay it, look at it, and make recommendations to us for next year,
And
if any. We're not costing you any money.
And I will tell you, Mr. Chairman, that the judges were extremely disappointed when they saw that this was sending everything to OES. They wanted us to do it, so pass that along to OES.
Okay. All right. Does everybody understand the amendment? Well, no, we're not there yet. We got to adopt the amendment first, Bagby. Okay, Stewart moves and Boyce goes seconds the amendment. All those in favor say aye. Aye. Okay. Now we have an amended bill, no sub in front of us. Is there any, OES, you're good with the bill as is, right, for now?
Yes, Mr. Chairman, members of the committee, Alyssa Patton with the Office of the Executive Secretary. We support the payment of a per diem for retired judges to attend the judicial conferences and would be happy to look at it and make a recommendation on an hourly rate if that's the will of the committee.
Okay, I suspect the bulk of the judges this applies to are probably district court judges, right?
Excuse me?
The bulk of the judges this applies to are probably district court judges, not circuit, right?
For attendance at the judicial conference?
Yeah.
Both retired circuit court judges and retired district court judges
Right, but
attend the judicial conferences.
Right, but more of them are district than circuit, right?
I don't have the list in front of me. You mean are you referring to the number of judges on the recall list? Yes, I believe that's correct.
Yeah. Right. Okay. Okay. Is there anybody else opposed to the bill? No. Okay. Bill's been moved. Stewart moves. Jordan seconds. The bill be reported, referred to finance. Any of the feedback? Nope. Okay. Clerk will open the roll.
All three of mine are yeah. Oh, I can do it here. That's right. Did I get them all?
We'll see if
Ayes 15, no zero.
All right. 1067.
All right. Thank you, Mr. Chairman, members of the committee. 1067 is kind of a cleanup bill for our tobacco codes, and I've got some witnesses here, but briefly, 2 years ago, the Attorney General office learned that we have what are called retail tobacco deliverers, kind of like Grubhub or whatever. The people who take food to your house are now taking cigarettes to your house. So you can get automobile delivery of everything now, including cigarettes. But these companies are not registered and they're not keeping track of their retail sales. And what we've learned is that they're setting up these shops in towns, blacked out windows, all of those things. There's an app that you can get on your phone. You hit that app, tell them your info, and this was done on Friday, and they'll bring you a pack of cigarettes, and they'll look at your driver's license on your phone, and they'll look at the back, so it may or may not be your driver's license, but most importantly, they are not registering, they're not keeping track of their sales, they're not listed as retail sellers of cigarettes or tobacco products. So that's what I'm trying to address here. And I have someone, Mr. Sean Thornton, a witness, I believe. Yes, there he is. Come on up and tell him what's going on.
Good morning, I'm Sean Thornton. I've been with the OAG for 7 years, and I lead the tobacco enforcement section.
And what's the problem?
So essentially what we're trying to do is level the playing field and ensure that any company that is delivering cigarettes to a home purchaser has the same requirements for registration, reporting, and age verification, most importantly, as any other. That's all that this bill does.
Right, so you are concerned that somebody can evade the age purchase requirements by using Grubhub or something to deliver cigarettes?
They'd be welcome to sell them as long as they're doing it in compliance with the law, sir.
Right now, they're not.
Correct.
Right, okay. Any questions for the AG's office? No, okay. Does anybody oppose the bill? Is Grubhub out there, like selling cigarettes to underage kids? Anybody? No? Okay. Doesn't look like it. Okay, does this have to go to finance? Yes. Does?
Does this one have to go to finance? Goodness gracious.
Yeah, we're gonna be spending some time up there with us. Okay. Okay, Boyska moves, Deed seconds, that we report the bill, we refer it to finance. Clerk will open the roll.
Ayes 15, no zero.
Thank you, Mr. Chairman.
Okay. Now we're getting into the fun stuff. Stuart, you wanna go? Oh, yeah, I'm sorry. Bagby had his fixed. Senator Bagby, where are we? Which bill was this? What's the number again? 1255. Back to that.
It's easy.
And just for members of the committee, the conversation that we ended up coming upon was that the understanding after speaking with folks who do more juvenile work than I do and some other conversations that juveniles who are in custody have to have their detention hearing. So you would have counsel for the Commonwealth and counsel, they have to have counsel appointed. And so that helps, I think, address some of the, will there be counsel? Are we gonna jam up the process by not having counsel? And so procedurally, the way we move through the bill is that on lines, in subsection B of the bill, if we add in, unless such court orders the use of such restraint, and then we're gonna add in on motion of the Commonwealth or the court's motion sua sponte, prior to such a juvenile's appearance in the courtroom pursuant to subsection C. So I think if we add in that language right there, we make it clear that procedurally, the court or the Commonwealth can make a motion to have the juvenile appear in restraints. And then I have a second amendment down in subsection D.
Sorry, do we have language or is that concept?
Nope, that was language.
Okay.
Okay, Mr. Chair.
Yeah, Senator Deeds.
Mr. Chair, then read paragraph B to me,
Okay,
please.
paragraph B reads like this. Instruments of restraint shall not be used on a juvenile during a delinquency proceeding in a juvenile domestic relations general district court unless such court orders the use of such restraint on motion of the Commonwealth or the court's own motion sua sponte prior to such juvenile's appearance in the courtroom pursuant to subsection C.
Okay, is the word general on page 17, the printer, line 17, Surplus?
That's a great
Yes.
question. I had that conversation in the back of the room, and I thought about that yesterday, and apparently the Office of the Executive Secretary has insisted that that language appear there. It doesn't make any sense to me. I thought it would be the either the
called
district
general
courts
district
or the general district court and the general district court, but not all of them. But I understand from Mr.
Somebody over here is
Sorry,
saying.
I just wanted to correct, gentle correction. It was the Division of Legislative
Oh,
Services.
my apologies.
Okay,
Not,
hold on.
not OES.
Okay, but hold
So
on.
sorry.
There's no such thing as a juvenile and domestic relations general district court. They don't exist. It's
I
a
raised
ju-
that,
That's what I said.
same question in October
Right.
and was.
It's a juvenile and domestic relations district court.
That's right.
So, Mr. Chair, we would strike
So strike.
general on line
general
17.
As part of that amendment.
Right.
And the
Okay.
amendment, that amendment makes sense.
Okay, so that's the First Amendment. It's been moved by Perry, seconded by Bagby. All those in favor say aye. Aye. Anybody opposed? No. What's your Second Amendment?
Okay, the Second Amendment goes down to Section D, and it starts with, "The juvenile shall be entitled to an attorney at such hearing." That's an amendment. And then the rest of it will say, "The court shall provide the juvenile's attorney an opportunity to be heard before the court orders the use of instruments of restraint pursuant to subsection C." And then the next amendment says, "The juvenile's attorney may waive the juvenile's appearance for such hearing." And then the rest of that sentence is, "If such restraints are ordered, the court shall make," the word "written" is stricken because this is a court, not a record, "findings of fact in support of the order," period. So 2 sentences added in there that make clear the juvenile does not need to be brought out in shackles for the purposes of this hearing. The defendant, or the juvenile's attorney, can waive that, and the juvenile is entitled to such attorney at that hearing.
Okay. Any questions about that language? Makes sense to me. Anybody else? No. Okay, so Perry moves, Stewart seconds those amendments. All those in favor say aye.
Aye.
Aye. Anybody opposed? No. Okay, so the bill's amended is now before us. You guys poking glass, you guys are good now? Okay, anybody opposed to the bill with the amendments? Sheriffs, you still don't like it?
Yes.
Any attendees online
Hey, is there anything
opposed,
about the
please raise your
amendments that
hands.
make you, is there anything about the amendments you want to say that's different than what you already said?
Mr. Chairman,
Yeah.
I would point out to the Chef Association, this has nothing to do with them bringing them in. It is literally just from the lockup into the courtroom.
I understand that the amendments make a shift so that the juvenile's defense counsel can ask for the appearance to be waived to conduct this hearing in their absence, so we would avoid the shackles. Our fundamental objection is the same, that it moves the decision-making for courtroom security out of the hands of the experts in court security who have been tasked by Virginia Code to be the experts into the hands of the court and attorneys who may not know all of the information or have the expertise.
Mr. Chairman, if I can.
Yes, Senator Perry.
I would just suggest, I am very understanding that often the sheriff's office or whoever's doing the transport has a lot of knowledge about these juveniles and conduct and behavior. But I think I think the concern that's been raised is that we're having this process used, and I think we can all agree that it should not commonly be used. Is that fair?
I agree, and I think the sheriffs are very clear that they agree with that as well.
And so I think as we discussed earlier, the bill is really trying to get at some sheriffs using this all the time without looking at each case individually. And to be totally fair, I'm not sure how to get at this without legislating it, right? If that is what's happening, and we can agree that it shouldn't be used as a blanket rule. I do understand it needs to be used in some circumstances, and I would say the answer to, hey, defer to, our judgment, we may have information no one else has, is the Commonwealth is involved in this. And certainly you all can go to the Commonwealth and say, hey, A, B, C, D, E, F have happened, and that's what raises our concerns. That's why we believe the kid needs to be shackled, and you guys would have someone who could advocate for you at that hearing that, hey, this child does indeed need to be shackled. And so I really think that shifts it from being just blanketed, and I think people have tried to request that not happen, and it continues to happen. So I absolutely hear you. I just don't know a way to get around it without doing this.
Ms. Hobbs, anything else?
I don't have anything else. Happy to answer any other questions if there are any.
Okay.
I move to report it.
Second.
Okay. I don't think it does. Does it? No, it does not need to go to finance. It's been moved by Perry and seconded by somebody down there that we report the bill. Clerk will open the roll. Make it open, Shane.
Senator Peake? Ayes 15, no zero.
Yeah, let's go to Stewart. What do you want to do first, Stewart? Numerically, well, let me do the easy one first. 1392.
92?
Yeah, this is the ASAP Commission recommendation. Right?
So, Mr. Chairman, members of the committee, if you're convicted of a DUI, the way the statute essentially says is you can get a restricted license with conditions. And typically those conditions are you can drive to work, you can drive to childcare, medical appointments, you can go to church once a week. That was my bill many years ago, by the way. And that's sort of the default. What this bill does is it flips it, because as of a couple years ago, and I don't know if it was the chairman's bill or McDougal's bill, but there's a new provision that says you can get a restricted license for 12 months with 12 months of interlock. And I think like 80% or 85%, it's a big number now, just choose the 12 months with interlock. And what the judges, some of the judges said was it's a lot of extra paperwork. So they just rather have that be the default. If you're convicted, you get the 12 months with the 12 months of interlock. However, if you don't want that, you can petition the court to have 12 months loss with 6 months of interlock with additional restrictions. Did I explain that sufficiently?
Senator Deeds has a question for you.
So right now, the default is 6 months of interlock, and you can petition after the 6 months.
No. Right now, the default, you always lose your license for 12 months.
You lose your
period.
license for 12 months, but you can
But the
petition
difference
after 6
is-
months to get rid of the ignition interlock.
No. So you always lose your license for 12 months.
Right.
The default is you get interlock for 6 months, but you can only drive to work. You can only drive to a medical appointment. You can only drive, like if you have child custody issues, and you can drive to church once a week. Everybody is going for the other option, which is 12 months with interlock. And so this just, it makes it simpler for the courts.
We heard this it's recommendation of the ASAP Commission. I think it was, wasn't there some judges that recommended it, I think that.
Oh, yeah, I'm sorry. This is a commission. This is a VASAP commission bill. I apologize. It's been vetted by the commission. I believe it was unanimous. And it's not groundbreaking. It's just, it makes it easier because they're automatically going to do that unless the defendant says, wait a minute, I only want to be able to drive to and from work.
So it's
Deeds and
Chair, it's unrestricted permit with interlock for 12 months.
Correct. And that's something that happened, was that your bill?
I think it was my bill.
It was your bill. 2 or 3 years ago, and everybody chooses that now.
4 or 5, yeah.
4 or 5, okay. Well, time flies with you, Mr. Chairman.
Hey, Pete.
Thank you, Mr. Chair. And Ms. Stewart, Senator Stewart, just to clarify. So before as it stands right now, if your BAC is below a .15, then you can get ignition interlock for 12 months and drive
Anywhere you want.
anytime you want. But if your BAC is over a .15, you have to have ignition interlock for 6 months, and it's restricted, and then you are restricted for the next 6 months.
Correct.
Without the ignition interlock.
Correct.
And sometimes judges may do it, ignition interlock and restrictions for 12 months for over a .15.
I don't think so. I don't think they do. I think it's still 6 months. Somebody correct me if I'm wrong. But it's restricted, so I can, and I don't know how many of y'all have done these, but I mean, literally you have to say what time you leave home in the morning, what time you get to work, if you're allowed to drive during work, and if you're outside of that, it's a Class 1 misdemeanor with a significant suspension of your license if you do it.
Yeah.
So it's a pretty serious offense.
Mr. Chair, but in that, that's if you're over a .15, correct?
Yes.
If you're, but now.
You don't get this option that I'm offering today if you're over a .15. Correct.
But after this, Mr. Chair, with your amendments, the judge will have it simply can do 12 months ignition interlock.
So You don't have to say anything. If you get convicted and you're standing there and the judge is pronouncing sentence, he's going to automatically say, Senator Peake, you lose your license for 12
I
months.
hope he doesn't ever say that to me,
You
Mr.
lose your
Chair.
license for 12 months. You lose your license for 12 months. You got to have ignition interlock for 12 months, but you can drive anywhere you want for any reason at any time, day or night.
Thank you, Mr. Chair. That's
And you
what
can say, but wait a minute, Judge, I don't want to do that. I want to have 6
Chairman.
months of interlock.
Peake, I thought you were going to say, I don't understand this because none of my clients are ever convicted like Senator Stewart's.
Thank you,
I
Mr.
would
Chair.
point out, Mr. Chairman, that you're the guy who had the bill to start with, so
Yeah, okay.
you must have had a few.
Yeah, mine don't get convicted either. Okay. Basically, this just conforms to common practice. I'm not really sure it makes a big difference one way or
Just
the other.
it conforms to what's currently happening in the courts today. That's exact, and it saves them some paperwork.
That's right. Okay. Are there any other questions for Senator Stewart about this one? Doesn't look like it. Okay. I know the Washington Regional Area Alcohol Program, VASAP supported. Is anybody opposed to the bill?
Any attendees online in opposition that would like to speak, please raise your
Doesn't
hand.
look like it. And I don't think it needs to go to finance. Okay.
Shouldn't.
Okay, is there a motion? A motion?
Saves court time.
Okay, Peake moves and Stanley seconds that the bill be reported. Clerk will open the roll.
Thank you, MJ.
Okay.
Senator Carroll. Ayes 15, no zero.
Okay, bill reports. And your next one, we've heard before, a little more fun.
Thank you, Mr.
and
Chairman.
Interesting.
Senate Bill 918, and you're right, the Senate passed this with large majority some years ago, only to languish in the House of Delegates because of their short-sightedness. So 5, 6, 7 years ago, and again, I'll defer to the chairman on this one because you probably remember it because your mind's a lot younger and better than mine is. There was a case called Seraphin versus Commonwealth. And what that case said essentially was that you can be arrested and prosecuted for a DUI on your own property. And the theory was that, well, if you were driving on your own property or parked in your driveway, you must have been on the highway and you must have been drunk driving on the highway. And so when we stop you or see you in your driveway, we should be able to arrest you and prosecute you. And I actually had that case some years ago, and I won it on the facts of the case, not on anything else. But the guy was sitting in his driveway. His wife didn't let him smoke in the house, and he was watching football. It was cold as the dickens outside. He went out and sat in his car, and he was smoking a cigarette and drinking. This is the truth. The officer came along, somebody had called a welfare check because they saw him sitting out in his car in his driveway. They pulled into his driveway, arrested him, and charged him with drunk driving. And that's perfectly allowable. That was good under Virginia law, under Seraphin. What this bill says is you can't do that. You can't arrest somebody for DUI on your own property.
Mr. Chair.
And keep in mind that you can get arrested if you're driving your golf cart in your yard, your lawnmower, your gator, a number of things.
And Mr.
Hold on,
Chair.
Senator Deeds, 1 second. I believe the example that Chief Justice Kinzer at the time gave in the oral argument was you could be sitting in your mobile home on the side of a mountain.
Yeah.
Have it on to stay warm, and you'd be charged with DUI, right?
Well, yes, and she was the one who really knew what she was talking about because
Okay,
she was the
Senator Deeds.
dissent in that case.
And Mr. Chair, if I own 100 acres of bottom land, and that's way off the road, way off the highway, and I'm spotlighting deer, and I just stop. If I'm spotlighting deer, doing
Well,
whatever I want to
you're
do.
not shooting them though.
I'm
You're
not
just
shooting
looking,
them. I'm just spotlighting deer, just looking at the deer,
drinking a beer.
drinking a beer, and I drink 12 beers.
Yep,
And I'm 3 miles off the highway. And so that's my land.
that's correct.
But I'm still subject to being arrested for DUI.
That is correct.
And nothing about this bill will change that.
It is an unconscionable.
not my curtilage.
It is an unconscionable invasion of privacy. It would change it. So now you can do it.
No, you can't, because it's not residential property or residential curtilage, or not necessarily adjacent
Well,
property.
fix it then, please. Add an amendment. Come on, give me an amendment.
Yeah, Senator, you're not speaking from personal experience, I'm sure, right?
I'm not speaking from personal experience. No.
Uh-huh.
I've seen your bottom line.
So that's the policy, Mr. Chairman. If people support the policy, we can get the language right. I'm not concerned about that. The insurance companies will hate it. There's some others that will hate it. But, and you know, I don't even do this. I don't even drink anymore. But you ought to be able to drink as much as you want on your own property if you're not bothering anybody.
Mr. Chairman.
Okay, Senator Perry has a question.
I do have a question. The issue is, I don't think the issue is that you can't drink as much as you want on your own property. And I'm sympathetic to the arguments that you're making, and I think you're making a lot of good arguments. The issue becomes when you drink and become intoxicated as defined by Virginia code, and then get behind what is often a deadly weapon, a motor vehicle, right? And so I just want to be really clear that this doesn't prohibit you from drinking and being as drunk and passing out or whatever in your home. What it prohibits you from is then getting behind a deadly weapon and operating it. And that's really my concern, because let's use it. It is on your property, and we allow people to do a lot of things on their property, but there are also things we don't allow them to do, even if it's on their property. For instance, if you're prohibited from possessing a firearm, you still can't do that even if you're on your own property. There are laws and things that we don't allow because you are just prohibited from doing it. And my concern is the reason we don't allow people to operate motor vehicles while they've been drinking is because it creates a danger to other individuals and to that individual. Your inhibitions become lowered, right? I think this is why we went back or why the definition of operation is so broad. And let's say, you know, you are on your property and you're sitting out in your car and you're listening to the game on the radio, drinking, and you go to reverse the car back because you need to move it into the, you know, right next to you in your parking spot or whatever, and there's a 2-year-old playing behind you, right, on the driveway. That's on your own property. Mm-hmm. But now you've been allowed lawfully to drink as much as you want, be as drunk as you want, and now we've said, and you can operate a motor vehicle. And I just am concerned about the danger that it potentially causes to other people on that property who are on your property, who we now have written in explicitly, hey, you are permitted to do this thing with a deadly weapon.
Well, I don't disagree with that. What you're saying is true, but that applies not just to a car being a deadly weapon. You could be convicted in a golf cart. You could be convicted on small motorized things that are not really such a deadly weapon, and there are other crimes for that. There are other charges that you can do for that. There's civil liability if you harm someone. So you're still accountable for your actions. But I'm just not sure that we as a body should be legislating every aspect of personal responsibility when you're on your own property. You should have the freedom to make bad decisions on your own property. And more often than not, you're not going to see any of those scenarios that you just described. But what you are going to see is the guy cutting his grass with a beer in his hand, and he's going to get arrested for DUI because of plain view from the road. You look at me, but this is the problem. This is the issue that I'm trying to solve. If you're on the road, they're going to arrest you on the road. There's no question about it. This is the person who does not understand the fact that they can be arrested in their front yard cutting their grass on a lawnmower while they're drinking a beer.
Mr. Chairman, if I can.
Senator Perry.
I was having this discussion yesterday because I'll be real honest with you. It was not my understanding that you could be DUI on a lawnmower or in a golf cart. And the reason for that is 46-100, the definition of motor vehicle, which references vehicle, which references something you can operate on a highway in the Commonwealth. And I don't know that you can operate a golf cart. I know in Leesburg, we provided specific things, and Senator Stanley's giving me faces down here and mouthing a lot of words that yes, lawnmower down. Okay, so you cannot be DUI in a golf cart, Senator Stanley said.
I've defended them. What are you talking about?
Well, maybe
They
you
could
need to make that
charge-
argument.
So I've got several.
Hold on,
I've got several
one at a
little
time.
towns in the area that I represent, and they have golf cart ordinances, and they drive them on the road. They get arrested for DUI on a golf cart all the time, and you can get arrested for driving a golf cart on your own property.
Okay, hold on. We're
while
not gonna have a
drinking
back
and
and forth. I know Jordan's been in the queue. Perry, were you done with your point?
I was wondering if someone could make a definitive comment on what qualifies as a motor vehicle for purposes of 18.266.
They write DUI on a golf cart all the time.
Hold on.
It is a
hold on.
standard charge.
Okay, one at a time. Ms. Fry, Benjamin, you got to answer to the question about, I know it doesn't apply to bikes or mopeds, right?
Right, it does not. We've had to dismiss DUI moped
Right,
cases.
Senator Perry? Yep.
Which I don't know if that makes sense
Is that
or not.
because it's under a certain CC?
No, bikes are explicitly excluded from motor vehicles under 46-100. Mopeds are excluded 18.2266.
Okay.
But what Perry's talking about is the interplay between motor vehicle in 46.200, and there's also.
Well, look, if you all don't
Senator
like
Stewart.
if y'all don't like it as a policy decision, then vote it down. Don't
hold on,
spend a
Stuart.
lot
We
of
still have
time.
more questions here. So I know Jordan's been in the queue for a while council tries to answer the question. Jordan, you have a question.
Thank you, Mr. Chair. Question for the patron. So it is my understanding that if this should pass, nothing stops a law enforcement interaction and charges them with drunken public if you pass the threshold of your home. Would that be correct?
Can you be arrested on your own property for drunken public?
What I'm trying to say, Senator Stewart, is I think to what Senator Perry was mentioning, you can still be charged with drunken public on your front yard if you're outside the threshold of your home. Would that not be correct?
Senator Jordan, I think the front yard, usually backyard, usually not, kind of depends on what in public is, and that's complicated
But wait a minute.
analysis.
But wait a minute. Yeah, he's
Yeah,
right.
Senator
But the only way you're going to get arrested for drunken public in your front yard is if you're standing in your front yard, slobbering drunk, screaming and cussing at people. You could be very calmly and responsibly driving your lawnmower, cutting your grass while drinking a beer, and get arrested for DUI. You lose your license for 12 months. It's a Class 1 misdemeanor. You have to go to VASAP. You have to pay a number of fines. It's a significant difference. Drunken public's a $25 fine.
Mr. Chair.
Yeah, Senator Jordan, and then I think Perry has something again. Yeah, go ahead.
That was a friendly question, I believe.
Okay.
Mr. Chair.
All right, Perry.
Sorry.
And then I think council has an answer.
I didn't view it as such.
Okay. Hold on, Perry.
I just want to push back on the idea that you can drink a beer and be driving a lawnmower and be arrested for DUI, because the law still requires that the Commonwealth prove intoxication. And off of a beer, unless this is some really high potent beer,
Accurate. That's not accurate.
that you're going to have to prove.
Senator, hold on.
That's not
Let her
accurate.
finish. Wait.
Okay.
There's a lot of talking over each other going on. We need to have some structure.
That officer could prove that they had probable cause to believe that person was under the influence of an intoxicant, which is defined in 4.1, right? Because that the alcohol had affected their manner, their speech, their disposition. And so I think you're gonna have to have more than a beer to do that. I'm just pushing back on that exact example. If lawnmowers qualify, I think if you have several, then yes, then that, your point is made.
Stuart, you want to respond to that? Then we're going to go to council for the answer.
Mr. Chairman, that is correct to a certain extent. You can do that by the facts, by pointing out the observations, and so say it's 2 or 3 beers. What's the difference? But if they are responsibly driving their lawnmower, cutting their grass, why should they be arrested for DUI unless they run out in the road or something? This is my difficulty with this whole policy.
Council. Do you have an answer about vehicles?
I do. In Mr. Chair, Senator Stewart, in section 46.2-100, your golf carts are included in the definition of motor vehicle. The only things not included in the definition of motor vehicle are bicycle, electric mobility device, electric power assisted bicycle, motorized skateboard or scooter, moped or personal delivery device. And I believe that's why moped was added
Okay,
to your
thank
code
you.
section.
So
Mr. Chairman?
lawnmowers, golf carts, exactly what I said, a
Okay.
gator.
Senator Perry,
If I can, I believe the analysis is slightly more complicated than that because it does say that in the definition of motor vehicle in 46-100, but the definition of motor vehicle references the definition of vehicle, which is also in 46-100, which then references things that can be operated on a highway in the Commonwealth. And so I think you're going to have to like move through all of those steps and go look somewhere else. I'm not suggesting. I think the complexity is that 46-100, the definition of motor vehicle, does not necessarily cover everything. That was my question, if that makes any sense. Not.
okay, so I'm not sure where we are, Deeds. You don't want to broaden it beyond the curtilage, doesn't sound like, into spotlighting deer in your bottomlands. But I think we've had a pretty thorough discussion where we are right now. It looks like we have some speakers. Why don't we go to support and opposition? I suspect you don't have anybody in support, right?
I didn't ask anybody to support.
No bottomland deer hunters, spotlighters? No? Okay.
They don't even know the bill's coming.
Yeah, okay. Okay, so why don't we go to opposition? 3 minutes.
Any attendees online in opposition that would like to speak, please raise your hand.
Go ahead.
My name's Justin Griffith. I'm the Commonwealth Attorney for Pulaski County. I have the opportunity to be here today on behalf of VACA. I'd like to start out to say, respectfully,
I put a 3-minute timer up.
I don't believe you can responsibly drive at all while being intoxicated. You're still being irresponsible if you're going the speed, you're in the lines, if you're in your own yard.
What if you're just sitting there just trying to stay warm?
Well, that's a bad Commonwealth attorney decision. They should be short-time Commonwealth attorneys. What you referenced would not happen in Pulaski and should not happen anywhere. What we oppose is there's mobile home parks where people will be intoxicated driving throughout. There are apartment complexes where they will be driving throughout. In order to get arrested for a DUI on private property, you have to be doing an overt act to bring attention. A law enforcement officer has to come. You have to be intoxicated. They have to make the decision for public safety. They need to arrest you. A magistrate has to concur. A Commonwealth attorney has to read the report and say, you know what, this is so bad we need to go to court. A judge has to hear it. A judge has to convict. There are already 5 to 6 levels that these situations can be vetted through.
Okay, I think you've generated some questions up here, but the first thing I just want to mention is, I'm not sure Stewart's worried about the Commonwealth attorneys. I think he's worried about people getting charged and having to go out and pay a bunch of money for a lawyer to deal with the situation while they're just trying to stay warm. But beyond that, you said apartments and complexes.
Right, that's
people
a
driving
public
through mobile
area.
homes and apartment buildings. They're not in the curtilage. They're in a parking lot. That's not the curtilage, right?
Oh, I believe a mobile home has a curtilage.
It does, but when they're driving through the complex, they're not in a curtilage. They're driving down a road through the middle of the mobile home complex, right?
People are going to drive all kinds of objects all around mobile home parks.
Right, but that's not the curtilage of a specific trailer.
So you want them to part and parcel, well, hey, I can't drive here, but I can drive here. They're intoxicated. They're not going to be logically dissecting what's curtilage and what's a roadway.
Okay, so Deeds has a question. I think somebody down here, Dougal had a question.
Only point I was going to make is that for the most part, on this private property, the implied consent law is not going to apply.
I'm sorry?
The implied consent law is not going to apply. That's another barrier.
We already give deference to private property. We already say, hey, bud, because you own this property, we're not going to make you give a blood or breath sample because you're not on a public highway. So these laws already give deference to private property owners in that aspect as well. But it all comes down to discretion. Bad facts should be vetted out by the individual prosecutor and law enforcement. What they're describing should not have happened.
Okay, McDougal, you had a question? I think Peake has a question too.
I think the statement about mobile home and apartment complexes is what jumped my attention. And so curtilage is not defined in the code. I guess it would be, Senator Stanley pulled up a definition which would say it's the property immediately surrounding your home. And so how far is the curtilage of your mobile home or going forward? And what if we have a lot of campgrounds in my area, and in the campground you might have a camper. Some of those are more permanent than others. So if you're driving that golf cart in that area, where is that considered the curtilage? So those would be my questions around some of this. If you're on your physical property, I probably have less concern But curtilage, I think, might be defined as a little bit more than your specific property.
Mr. Chairman, just to point out for Senator McDougal, the bill says driving or operating a motor vehicle on his residential curtilage or his adjoining property. So that would not apply in a campground. It would not apply in an apartment complex. It would not apply in a mobile home park. His residential property. That's not a mobile home. That's not a trailer. That's not a camper. And if you're renting, it's not yours.
Yeah, in response to the Commonwealth's attorneys, Senator Stewart is correct. It doesn't say on private property. It's restricted to their property and curtilage thereof. And I would say for Senator Deeds, it also says adjoining property. So I think that would cover your 100 acres of
I don't
body.
want my neighbor driving intoxicated his ATV while my kids are playing outside. And you're also protecting.
Well, then your kids would be trespassing on his property.
Hold on,
This
Pete.
adjoining.
Mr. Chairman.
Okay.
You're also protecting the individual himself. You're protecting the person driving the golf cart and the ATV. It's not just about other people. It's not about curtilage. It's a public safety bill.
Mr. Chair, it's hard to protect people from themselves. I've been proving that for 62 years.
Okay, I'm going to start the timer back up again.
I just think it comes down to good discretion. You're warming up, you worked on your Camaro in your garage, you're listening to the radio, you're drinking beer, you have a fight with your wife, you go out to your car intoxicated. That's not what prosecutors should be prosecuting. It's the people that have came home from bars or on their property. It's the ATV manslaughter we had in Pulaski, where you're driving on your own property with your buddy and you flip a gator and he dies inside the gator with you. That's the intent of the law. And the prosecutors, I would like to think, would know the difference between, respectively, what he's talking about, what Mr. Stanley's client went through. We want to protect the individuals and we want to protect you regardless of where you are. Thank you.
Okay.
Mr. Chairman, can I just ask a question?
Go ahead, Senator Perry. Stop the timer.
With the example that you just gave in the ATV manslaughter, and Senator Stanley, this is a question for you, and I don't actually have your language right in front of me right now. Would for that DUI manslaughter, would it be prohibited too if it was on someone's property? Are you expecting that would encompass it if you're driving an ATV DUI with your buddy on it and you flip it and kill that other fellow? Am I prohibited from prosecuting you for DUI manslaughter?
I'm not prepared for that, so I'm thinking through it. You don't have to be convicted of a DUI to be charged with DUI manslaughter, do you, Steve?
I think that's right. I think you're right about that.
Mr. Chairman, Senator Stewart, I don't think you have to be convicted of DUI, but the death has to be caused by driving while you're impaired.
So I think you could still be charged with DUI manslaughter.
Hold on, that's only, first of all, are we talking DUI maiming or DUI or involuntary manslaughter?
I was talking about, well, it would probably be aggravated involuntary manslaughter, but it could be involuntary manslaughter, probably either or, but that's the question. We can talk about maiming as well.
But manslaughter doesn't necessarily require the predicate for DUI. It's just the gravamen of the offense and whether it's criminally negligent or whatever, right?
Mr. Chairman, that's right. Mr. Chairman, you are correct. That's common law manslaughter, but because DUI manslaughter wasn't considered to be regular manslaughter, the General Assembly passed a statute making DUI manslaughter, if you follow me. So you have to be, the death has to have been caused by driving while you're impaired under this specific statute.
Mr. Chairman?
Yeah, Senator Perry.
Okay, I'm just looking at 18236.1. I think this is in line with what Mr. Benjamin is saying. It says, any person who as a result of driving under the influence in violation of clause 2, 3, or 4 of 18266, or any local ordinance substantially similar thereto unintentionally causes the death of another person shall be guilty of involuntary manslaughter. So I think it's possible, right, if you're not guilty of 18266, that you then would also not be guilty of involuntary manslaughter in this scenario that Commonwealth's attorney from Pulaski County.
Yeah, Senator Deeds.
Chair, maybe not under that section, but you still could be found guilty of involuntary manslaughter under the general code section.
If you could show it, if you meet the show.
That's right.
Involuntary, why not voluntarily? If you get drunk and go ripping around with somebody in your ATV and you flip it and kill them, why involuntary? I don't know, but I'm not prepared for those this
Listen,
morning.
we've already spent, 20, 25 minutes on this at least, and I've got
Sorry.
A couple minutes left. Come on up, Regional Action
You all need
Plan, then we're going to wrap this up. 50 seconds.
Thank you, Mr. Chairman. I'll be brief. My name is Kurt Erickson. I'm president of the Virginia-based nonprofit Washington Regional Alcohol Program, here representing RAP, but also AAA, Mothers Against Drunk Driving, Virginia Association of Chiefs of Police, Drive Smart Virginia, Foundation for Advancing Alcohol Responsibility, in opposing this legislation. And I say this out of respect for the sponsor, for the fact that we're a fan of both his VASAP bill, but also, Mr. Chairman, yours that's coming up. Just 3 quick points. One is, this really bifurcates Virginia's DUI laws, that it effectively communicates that it's okay to drive drunk here, but it's not okay to drive drunk here. It would appear to be a solution in search of a problem. I don't know of court dockets in the Commonwealth that are swollen with persons being regularly arrested for drunk driving on their own property. And third and lastly, as the Commonwealth attorneys had said, this has the potential to jeopardize the appropriate penalty should a drunk driver kill someone on their own residential property. And for those reasons, we oppose this. Thank you.
Thanks. Okay. All right. Anybody else opposed online? Time's expired. Okay. All right. Bill's before us. Stuart, we got no amendments to it.
So if everybody hates it, it must be a good bill, right?
Yeah.
If I could say just one more thing.
Perry, final
I know,
words.
I'm
we
tired
wrap
of
it
my own
up.
voice too.
Yeah.
18251.4, maiming of another resulting from driving while intoxicated. It also says any person who has a result of driving while intoxicated in violation of 18266 in a manner so gross, wanton, and cause show reckless disregard for human life, unintentionally causes serious bodily injury of another is guilty of a class 6 felony. So I think it also would eliminate if I maim someone else on my property while DUI. I think you also kill the DUI maiming statute, and so I'll just point that out.
I don't know. I'm not prepared to debate that point of it. There are plenty of other charges. You could still get them for maiming. You could still get them for.
I agree with that, and the criminal penalties aren't the end of the story. They're also civil penalties.
Right.
So I move to report the bill.
Okay. Is there a second down there? Okay, it's been moved and seconded. The bill be reported. It's be an interesting vote. Clerk, open the roll.
McDougal?
Ayes 7, noes 8.
McDougal? Jeez.
All right, Stuart, you got us all mixed up there. I don't know what that pattern is.
Killed it.
McDougal.
Wow. McDougal.
This is not showing up at 5 p.m. again.
Okay. All right, next up, I told Jordan she could go because apparently there are 3 cabinet secretaries here waiting around for her. So, Jordan, what do you want to do first? Trespass or social media? Okay, 1272.
Thank you, Mr. Chairman. I'm not here on courts to admit any crimes today like everybody else, so I'm just going to talk about drones.
Okay, I can't hear you. Can you speak up?
What I have before you today is Senate Bill 1272, which you've seen a similar bill in Senator Locke's. We do have an amendment.
You an amendment or a sub?
A sub, sorry.
Yeah, can you make sure you lean into the mic? We're having a hard time hearing you. Senator
Lost my voice.
Shane
Sorry,
moves and
guys.
McDougal seconds. The substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay, the sub's before us. It's in your packet.
And just so you know, I'll speak to the substitute. What it does, it merely mirrors the same language that we used in Senator Locke's bill. It's just a separate issue. So what this seeks to address is trespassing with unmanned aircraft over critical infrastructure generation facilities, as well as military bases and installations. As we know, Virginia is a top-tier space for monitoring and particularly for foreign entities. And so this bill seeks to address our military bases and our critical infrastructure with the penalties for unmanned aircraft.
So this, I'm sorry, I'm still trying to figure out where we are. So this basically says you can't take a drone and drop something inside of a prison or take a picture of somebody in a prison.
It's the same language as Senator Locke's bill. It's just addressing correctional facilities, military infrastructure, and critical infrastructure.
Okay, but again, what the bill does, it prohibits you from using a drone to drop something in a prison or take a picture of somebody in a prison, like in the prison yard, right?
Correct.
Okay. Senator Deeds.
Is that what it does that's different from the bill we've already passed?
It's
No.
And critical infrastructure, like the shipyard.
Yeah.
Right.
Okay.
Yeah.
So same bill, just different places.
Okay. Anybody have any questions? No questions. I assume the administration's support of it. Is there anybody opposed to the bill? You can drop it in the curtilage, just not inside the prison yard. Yes. Google, you have you're opposed to the bill? No. Okay. What does Google think about this?
The Guy Rolling from Albertson Company, I'm representing Wing. Wing is a subsidiary of Alphabet. Wing operates the first commercial, FAA-approved commercial drone delivery facility in the United States, headquartered in Christiansburg. And just wanted to make sure that the committee was aware of that, and we operate under rules established by the FAA. They control where we can fly, and our concern, I think we don't have a concern with the bill now, but I wanted you to be aware of that, so.
You want us to be aware that there's a commercial delivery service in Christiansburg?
We wanted to make sure that there are no restrictions on their ability to operate as long as they're operating under FAA approval.
But, Mr. Chair.
Yeah.
FAA approval would not authorize a delivery to a state correctional institute or a local jail.
That's correct. We would not.
Okay.
Go ahead.
Mr. Chair, I'm familiar with their delivery system. Actually, they drop bagels and coffee in Blacksburg. So I don't think they're the intent of this bill or a target.
Okay, so, Senator Jordan, I noticed that it says "or." I assume the FAA special security instructions or UAS security-sensitive airspace restrictions are. Do you know if those restrictions are included in, like, when you turn on your drone and it has a geofenced area you can't fly it over? Is that what that involves?
So some things are pre-programmed, I understand, to know what those areas are. So I believe yes.
Mr. Chairman.
Okay, who is that? Favola?
Yeah, question. I know it says knowingly and intentionally, so that's probably a good qualifier, but would an individual necessarily know where a judicial correctional center is or a state correctional center? Is there a map somewhere, or is there a site we could reference, or?
So there's a couple different types of drones. First of all, if someone's going over a correctional facility in Virginia, most of our correctional facilities are well over 500 or 1,000 acres, so I would be certain that they would know. And many drones are actually pre-programmed to know where sensitive areas that are no-go zones are.
Is that, you're Secretary of Public Safety, right? Yes, sir. Can you come on up for a second? Do you know what I'm talking about? So I have a drone. And when you download the map, it has certain areas that are geofenced that you cannot fly a drone over unless you're really good at programming, figure out a way to break the drone software or something like that. Do you know these areas, the FAA, special security instructions, UAS, security-sensitive airspace restrictions, are those included in the current geofence stuff that consumers can't access? Like they can't fly the drone into?
Yeah, Mr. Chairman, my understanding is they are not. There are some military facilities that are included in the DJI drones specifically, but there are others, such as the correctional facilities, such as the critical infrastructure, that are not listed. In being in Virginia, we have close to 100 pieces of critical infrastructure here in the Commonwealth.
Take off or land in violation. But basically under this, it wouldn't necessarily be illegal to fly over it. It's just illegal to take off or land inside of it or take a picture of an inmate in one, right?
So the majority of the 88% increase that we've seen with drones flying into the space, flying into the correctional facilities, have been bringing contraband drugs, cell phones, chargers, and other illicit material.
Okay, but the way I read the bill, I'm trying to understand your intent. I'm trying to understand what you're trying to accomplish. Does this prohibit somebody flying a drone over it or just taking off or landing in it?
Flying over it, sir. That's my understanding. Is that correct?
But the qualifier's intent.
I don't read the bill saying that.
The bill speaks to an intention.
Okay, the bill says, I'm gonna read it to you. It says, any person who intentionally causes an unmanned aircraft to take off or land in violation of this stuff. And then it says, including the airspace over any correctional facility. So it's take off or land over the airspace of one of these facilities. And then the second part has to do with dropping items. It's not clear to me that it necessarily prohibits flying over one. Maybe that's your intent. I don't read it that way.
But Mr. Chair?
Yeah.
Might I ask Mr. Benjamin if this mirrors, I believe, the same language from Senate Bill 757? It was Senator Locke's bill around shipbuilding facilities.
Want to go to your next one?
Mr. Chairman.
Yeah.
For what it's worth, while we're looking at this, I agree with your interpretation of the language. I think it's just confusing. I think if your intention is to prohibit people from flying over it, then I think at the beginning where it says any person who knowingly and intentionally causes an unmanned aircraft to one, take off or land or drop any item is two. I think it says, and then you, as including part of that sentence, take off or land, or then including the airspace over any state or local correctional facility. I think we modify the language, and that's maybe irrespective of what was included in Senator Locke's bill. I think the point is to try to prevent people from taking photographs, dropping items into prisons, and so I think that's Senator Servel's concern.
Do you have a friendly amendment you'd like to offer, Senator Perry?
This I think requires a lot more surgery than that, if that's what it's after. I mean, I don't quibble with the idea of people shouldn't be dropping things inside of prisons. I don't understand what the FAA special security instructions or the UAS security sensitive airspace restrictions are. I don't know what that is. I don't know what whether they prohibit takeoff and landing or flying over or what. I don't know where they define areas, but the interplay of all that together, I'm not sure the way this is written covers flying over, if that's what you're trying to get at. And so,
Mr. Chair, what I may recommend, if council would be okay with it, is on line 18 to 19, if we strike take off or land, if we can find verbiage for traveling over.
That might get there. I still don't understand what these special security instructions are. Yeah, why don't you take it by temporarily? And Senator Perry, I know, worked on a similar bill to this. Why don't you go over in the corner? Not right now. We'll do your other bill first, and then you go in the corner with her while we're doing some of these other ones and come back to you, okay?
Do you want me to go ahead and do the other one?
Huh?
Do you want me to go ahead and do the other one?
Yeah, why don't we hop to your next bill?
All right.
Which is
1345.
Social media. 1345.
Thank you, Mr. Chair.
So this was identical to Senate Bill 532 last session, which was PBI 9-6 in this committee.
Correct. There is one amendment. You do not have, okay.
1392.
I can give it to council real quick.
So you have an amendment?
It's just a line amendment on line 19.
Line what?
Line 19.
19?
Mm-hmm. Yeah.
I'm sorry, it's not 1392. Which bill is it?
1345, Mr. Chair. And we don't have a copy of the line amendment, but I can report it. On line 19, after medium, insert, for the purposes of this section, social media account does not mean an interactive gaming platform.
Go ahead. I
Sure.
don't have the print copy in my book.
Mr. Chair, we don't have a,
No, of the original bill. Say it again. Line 19 what?
on line 19, after medium, I believe the first instance of medium, insert, for the purpose of this section, social media account does not mean an interactive gaming platform.
Okay. Senator Obenchain moves. McDougal seconds that line amendment. All those in favor say aye. Aye. Anybody opposed? Thank you. Okay, why don't you explain your bill, Senator? And remember, we heard it last year. We don't need to hear a long explanation. We already heard it.
We did make just the one line amendment to exclude gaming platforms. So what the intent of the bill is, we saw last year, and we've talked about it specifically. We know that social media causes severe issues, specifically mental health with our youth. Unfortunately, the hours between midnight and 6 a.m. are the most prevalent increase in suicides, 3.6 times more likely for youth to commit suicide during those hours. And we also know consequentially that the majority of online bullying happens when parents aren't able to watch. We would hope that kids are sleeping during these hours, but the reality is that we have young people that are, doom scrolling all hours of the night, not getting proper sleep, and also being subjected to, bullying. When many of us were growing up, we would go to school and we'd come home, and if there was a problem, you had that reprieve. Now children don't have that, unfortunately. It's leading to depression, mental health, bodily shame issues, and the like. And so we wrote this bill very intently and narrowed it to make sure that a child can go to work and come home, and that it's before school hours. And so I know that you all saw this bill, but since California, Texas, Utah, New Jersey, and other states have followed suit to do similar bills such as this.
Okay, Senator Deeds.
Amendment basically means the kids can, while they can't do social media, they can stay up and play games all night?
One would hope not.
But they can under this
Right,
amendment.
but so there's a lot of games that are on certain things as iPods and other nature that do have connectivity to the internet. So I think it was important to differentiate that. Social media, though, you're having so many different people that are interacting with messaging and the like and content and advertising.
Okay. And Senator, most of the social media platforms today have parental controls on them where parents can actually set things if they want to, right?
They do.
Okay. Anybody else have any questions for Senator Jordan?
Mr. Chair, I would say to you that not every parent is tech savvy or grandparent, maybe if they're raising a grandchild. And, this is really to protect kids. Every single platform that's out there has the capability to do this, as we've seen when they've complied with other provisions of the law.
Okay. All right. Why don't we go? We've already heard this bill. I assume you're up here because you want to testify in support? Okay, the secretary's here. Come on up. You said it 3 and 3.
Good morning, Mr. Chair, members of the committee. And I know that this bill was heard last year. I think what's different than last year is that our children's mental health outcomes are even worse. So I hope that you will keep an open mind and be supportive of this. I'm here this morning to speak to the health aspects. Sleep is important enough that schools bumped the start time from 7 a.m. to 9 a.m. in high schools just recently to recognize this importance. Sleeping fewer hours affects attention, behavior, learning problems. It increases the risk of accidents, injuries, hypertension, obesity, diabetes, and depression. And insufficient sleep in teenagers is associated with increased risk of self-harm, suicidal thoughts, and suicidal attempts. Secondly, while many of these apps do have parental controls, as we all know, if you are a parent, they are not always foolproof or safe-proof. Parents should not have to spend hundreds of dollars on outside of app solutions to keep kids off of their phones and protect their physical and mental health. Lastly, even President Biden's U.S. Surgeon General in 2023 released a health advisory about social media and its potential harm to kids' mental health. As the senator has said, many other states have passed similar bills. I just think in closing, as you all know, 41 attorneys general have sued Meta and other companies because of this effect on mental health. The impact of social media on kids will either be settled with legislation or litigation. Legislation is faster, and I hope that you will act now to prevent further harm to kids.
Okay, 1 minute, 15 left. Anybody, any questions? Anybody else in favor? Let's reset the timer. Opposed? Facebook, you here? Link, who are you with?
Northern Virginia Technology Council.
Okay.
Mr. Chair, members of the committee, Eric Link on behalf of the Northern Virginia Technology Council.
We have no comment on some of the testimony that's already been delivered. Our main concern is implementation. Places a civil liability on companies for failure to follow the law. There's nothing in the bill that addresses knowing deception. I know that all of you would start throwing a bunch of legal theories at me about, well, that would render this or that. The point of the matter is you can't implement a law that's based on a physical point and presence when there are things like virtual private networks available to teenagers to change the time zone that it appears they're in. And then, so if a teenager does that, how do you apply the law if one of their parents actually decide that they want to go ahead and sue a company because their kid was using that social media platform illegally pursuant to the law, but still deceiving the server, so to speak? Again, we don't have any quarrel with the goals embodied in this bill. The implementation concerns us greatly. Thank you very much.
Okay, thank you. Anybody else opposed? Doesn't look like it. Okay. Any other thoughts from Senator Jordan?
I'd ask that you look positively upon the bill.
It's been moved and seconded by Peak and Stewart that the bill be reported.
Substitute motion.
Okay. What's your motion?
Pass by indefinitely.
It's been moved and seconded the bill be PBI'd. Superior motion. Clerk will open the roll.
Mr. Chairman?
Wait, what? Somebody said something? Favola? What?
Just a quick question. Since we're passing by indefinitely, maybe when it comes back to us, there could be language about a regulatory body issuing guidance or regulations on implementation when it comes.
I think she might be.
Senator, passing by indefinitely means it's dead for the session.
Correct. That's what I'm saying. She's going to work on it over this session. But we're killing it. Yes, I do want to kill
Mr.
it.
Chair.
I'm expecting it's coming back. That's my.
Clerk,
Mr. Chair.
Clerk, strike the roll, please. Yeah, go ahead, Senator.
Might I ask that the chair send a letter to the chair of the Commission on Youth to look into this matter as COPA is addressed?
Sure. I'll send
Thank
a letter to JCOTS, ask them if they can look in at their options. It's up to them. That's
Thank
how
you.
we operate, but I'm happy to send them a letter. Okay, so PBI with letter is the motion. Okay? Boys, you good with that? Okay. PBI with letter.
Thank you.
Clerk will open the roll.
Ayes 8, no 7.
Okay. Bill is PBI with the letter. Jordan, I hear on your drone bill, we're going to take it by so that people can
Work on it and take it back for the day.
Yeah, okay, so your other bill, 1272, buy for the day.
Thank you.
Clean up your language.
Mr. Chairman.
Take a lot of testimony, but yeah, who was that?
I'm going to move to reconsider SB 918.
918. Okay, Senator 918, it's been moved. Senator McDougal asks that the bill be reconsidered, having voted on the prevailing side. Clerk will open the roll. This is on the curtilage, DUI curtilage bill we're just reconsidering. Can somebody hit Perry's button? Perry, you.
Ayes 14, no 0.
Yeah. Okay. Senator McDougal, you have a motion now?
I do, and that is to replace the language that says on his
we're gonna edit it.
residential
Okay,
curtilage.
Hold on. We're actually going to talk about it some more, okay? What was it again, 9 what?
18.
Okay, go ahead.
19.
On his residential property or his adjoining property.
Huh?
In essence, we're flipping out curtilage for property.
Or
I think
his-
curtilage has a definition under case law that means something more than what we're talking about, and so property is more restrictive and would not include mobile home places and not include apartment parking lots. It would just be physical property,
Just on Senator Deed's farm.
unless it's adjoining. So, that's my motion.
Okay, so it's been moved and seconded that we strike curtilage and replace it with property. All those in favor of that? Any further debate on that motion? Okay, I'll say aye. Aye. Anybody opposed to that motion? Okay, we've now amended the bill. Is there another motion, McDougal? McDougal? Big, somebody down there, you got a motion? Okay, it's been moved and seconded. We report the bill as amended with that amendment. Clerk will open the roll. Probably what? 9-8 now. 9-7. Deeds.
Ayes 8, no 7.
Okay, I foresee a fun floor debate on that. Okay. Senator Perry, you had a couple, right?
I have two, but I'd like to start with 894.
Okay, you want to do the fun one first?
Yes. I don't feel like we've had enough fun here today.
All right. Okay, it's been moved and seconded. We adopt the substitute. All those in favor say aye. Aye.
And I think there are some line amendments to the substitute. I think Mr. Benjamin has them.
Okay, hold on. Anybody opposed? No. Okay, the sub's before us in your packet. This has to do with vicarious liability for wrongful intentional acts by bad people. What are the line amendments?
Mr. Chairman, the line amendments would be as follows. Delete the current lines 16 through 20 in the substitute and replace those lines with the following. And so it would read, beginning on line 15, if, the employee's tortious conduct occurred while the employee was reasonably
Employee's tortious conduct what?
The employee's tortious conduct occurred while the employee was reasonably likely to be in contact with a vulnerable victim by virtue of such employee's employment, and 2, that such conduct proximately caused injury, death, or damage to a vulnerable victim.
Would only be 16 instead of 18 through 20 stays.
No, he struck
Does it?
2.
Okay.
Right? You want to strike paragraph 2, right?
Striking 16 through 20 of the substitute and replacing it with the language I just read.
So it's if somebody is reasonably likely to be in contact with the vulnerable victim by virtue of employment and it was the proximate cause.
Yes.
So we're striking anything about knew or should have known that they were reasonably likely to be in contact and the necessity of opportunity for control. Okay, does everybody understand the amendment?
Yes.
Can you read it one more time, please, Steve?
Okay, to set it up, an employer shall, subject to any available affirmative defense, be vicariously liable for the tortious conduct of such employee if, and here's the new language, the employee's tortious conduct occurred while the employee was reasonably likely to be in contact with a vulnerable victim by virtue of such employee's employment, and 2, such conduct proximately caused injury, death, or damage to a vulnerable victim.
Okay, does everybody understand the proposed change? Everybody understand it? Okay. Deeds moves, Boysko seconds the amendment. All those in favor say aye. Aye. Anybody oppose the amendment? Okay, Senator, so why don't you explain your bill as amended about vulnerable victims and civil liability?
Sure. Mr. Chairman, members of the committee, this is a bill that deals specifically with vulnerable victims. And that phrase is defined in subsection B of the bill, but really what we're looking at are a series of victims that are often comatose victims who are being taken care of in a hospital or in a nursing home, potentially people in other people in a hospital, but people who are under some sort of makes them a vulnerable victim, and that's really what this bill is looking at and trying to address. Healthcare patients, people who are under disability pursuant to 8.01-2, residents of a long-term care facility, nursing home, or assisted living facility, people who are at a spa. And the bill is really looking at the sexual assault of those victims or some other sort of intentional assault that happens to those victims where they are at a disadvantage to begin with because they are for some reason a vulnerable victim. This bill is brought about because the common law on these types of torts, which is the law that existed for, I think, about 100 years here in the Commonwealth, was that in cases like this, a person could sue that person's employer, and the idea being that the employer is in the best place to be able to know who they've hired, who they are giving the person they've hired access to, what kind of people that they will have access to, what kind of services will be performed on that person, and whether or not that's someone that they should employ, retain, and allow to entrust with some of these vulnerable people. In 2018, the Virginia Supreme Court started a series of cases which moved back, that, hey, the employer needed to be careful about who they hired, that they needed to be thoughtful about who they hired, that they needed to monitor the people that they hired to make sure that they were not doing some of the things that we've seen in some of the cases that come out of the Supreme Court, which are raping some of these people. We have seen a case here as of late, or sexually assaulting these people in their conduct. So for instance, it's my job to give a bath to someone who is in a hospital bed, and while I'm giving them a bath, instead of just giving them a bath, I engage in sexual abuse towards them. Because I've been left alone with them, and because my employer entrusted me and thought I was the type of person that should be able to engage in this behavior. What the Supreme Court has said, has gone back and said is, no, employer, you essentially have no liability or no responsibility for who you employ. And so that victim is then left, obviously they don't know who these employees are. They are left with little recourse. And the Supreme Court has really relied on the language that, I think it's particularly egregious, to be totally fair. It wasn't in the course of their employment, or it wasn't part of their job responsibilities to rape the person. And so you end up with this exceptionally, what I would call, skewed view that the worse the conduct is, the less likely the Supreme Court is to find that it was in the course of their activities. And so this bill really seeks to address that and take us back to what is more a restatement of the law of torts, which means where the law was, where it is in many other states, where in particular cases, and it's not all of them, it's not exhaustive, in particular cases with particular types of victims, that the court has to take that into account. And the court has to look at who these victims were, and particularly looking at things like sexual assault, or things like in the cases that I'm sure many of you guys have seen here, that's been reported, the neonate nurse who is accused of breaking the bones of those neonate infants, and potentially could cover a case like that. We believe that responsibility is best held and most easily held by the person who employs them, and that they should have some role and some responsibility in who the people are that they employ. And I, of course, have many other people here who can testify. I know there are people who are opposed to this bill, but I'm happy to take any questions or anything else from the members of the committee.
I think your chief co-patron want to say something too.
Mark Obenshane, or Senator Obenshane, my chiefest of all co-patrons.
Well, Mr. Chairman, a couple of things, and I thank Senator Perry for bringing this bill. This is not groundbreaking. This does not change the trajectory of the Earth's rotation. This really takes us back to pre-2019 or 2021, depending on which case you're looking at. And it really does look at who is in the best position to prevent this kind of harm. It really just returns to a jury the determination as to whether conduct is within the scope of employment. And I did this work, I still do this work, but heck, I defended these cases for 20 years. And, the seminal case, which is still the law, deals with a bus driver who gets cut off by another driver. He's so ticked off, he stops the bus, gets out, and punches the guy out. And the Supreme Court said, yeah, that's within the scope of employment. And what these cases in 2018 and 2021 really did was it drew a bright line just beyond that and said,
most cases, a jury will never have the opportunity to decide whether it's in the scope of the employment. So you take a child, say in the NICU at a hospital, and a nurse assaults that child, who's in the best position to have prevented that? Let's just further say that the nurse is one who had been placed on a disciplinary leave before this happened. Who's in the best place to prevent that injury to that child? It's the hospital. And the hospital they know that they are placing personnel in close proximity to these children. Let's just say that there's a child who's raped in a similar situation. Who's in the best position to prevent it? It's the hospital. And as somebody who runs a business, I've got a responsibility to the people that I deal with every day. And that's why I have insurance, not just to protect me, but to protect the people who may be hurt by me unintentionally or hurt by people who work for me unintentionally. And we've got more than just an obligation to protect ourselves. We've got an obligation to protect the people we are dealing with. And, if that child who's, seriously injured by a nurse or raped, some may argue, the remedy is that the person who perpetrates this goes to prison, and that's all good. They should, absolutely 100%. But that child or that vulnerable person is going to be left with the consequence of this, and under the test that's been established, they will have no remedy whatsoever, none. And this simply returns to the jury the ability to make that determination. And this new version, the substitute that's been offered, all it does is essentially offers the restatement of torts, section 317. And for those on the committee who are not familiar with the restatement of torts, it is generally the law nationwide. So this is not novel. This is designed to protect innocent victims, and I would hope that we would go back to the status quo ante before 2019, and that we would adopt this bill.
Okay, thank you, Senator. I'm sure there's a lot of people who want to testify on this. I'm going to set the timers at 5 and 5. Any other questions for the patron before we go to support and oppose? Yeah, Peak.
And I don't know if this is possible, friendly amendment. This appears to me to be subjecting the employer to strict liability, no standard of care. And if you look at line 13, and I guess it says an employer shall.
With
Is there a
affirmative
problem
with affirmative defenses?
And after employer shall, if the jury finds that the company did not exercise due care in hiring the employee.
That you're getting into a negligent hiring situation, which isn't what this involves. This has to do with just primary liability for the employees towards vicariously, not under negligent hiring.
This says if you hire someone if your employee sexually assaults a vulnerable person, you are liable. That's what it says. Shall be liable. That's what it says, line 13.
Not exactly.
If the employee's tortious conduct occurs while the employee is reasonably likely to be.
You could hire an employee who has never.
One at a time.
Mr. Chair, so under my reading of this currently, I could hire an employee who was a Boy Scout, retired military with the Medal of Honor, and he sexually assaults somebody while working at the hospital, and they are liable. It's not how this reads.
Senator Obenshain or Perry, one of you guys want to respond to that?
Well, no, it's not a jury question. It says shall be liable. It's no jury
Subject
question.
to affirmative defenses.
If what? If he did it. I'm saying he did it. Mr. Chair, I am saying that he did it. So if he did it, that's not the question. The question is, Yeah, because it says they shall be liable if he did it. So assume that the Boy Scout Medal of Honor winner hired on his very first day of work raped somebody, a vulnerable person. The employer is liable under this, the way I read this code section. Is that not true?
Senator Perry.
Mr. Chairman, I have Mr. Dix here to address Senator Peak's question.
Okay. Dix.
Good morning, Mr. Chairman. Mark Dix on behalf of the Virginia Trial Lawyers Association. With all due respect, Senator Peak, this is not a strict liability bill. What this bill does is it reopens a possible door for a jury to decide whether this is course and scope. And the last line inures to the benefit of plaintiffs. It inures to the benefit of defendants. A jury is now going to make that determination. And they can make that determination subject to affirmative defenses under these very limited circumstances. It's not everybody, it's vulnerable victims. There is reasonable foreseeable defenses for the defendant to say, well, golly, I had no idea he was going to do X, Y, or Z. And we can't conflate the direct cause of action for negligent hiring and retention with vicarious liability, which is irrespective of the employer doing absolutely everything right. Under these set of circumstances, a jury may determine just course and scope, that piece, but you still have to prove duty, breach, causation, damages, all of the other things. But under the test that currently exists, because of these three decisions, there is no more vicarious liability for intentional torts, period, hard stop. Because what the Supreme Court has said is that the only time you can hold an employer vicariously liability for, say, a rape is if I can prove, number one, that the rape occurred at the exact same time as a job function. I can never prove that. I am never going to be able to line up rape with something on a job duty at a hospital. It's not going to happen. And number two, I have to prove that the rapist was at least motivated in part by a desire to serve the hospital, to make them happy. I can't prove that either. The rapist isn't going to admit that. The hospital's not going to admit that. This is an impossible test. There is absolutely no way under this standard that exists for you to determine that an intentional tort occurred within the course and scope of employment. We're just providing a window. We're providing a window for the jury to determine under a very small set of circumstances.
Okay, Pete.
Yeah,
Member,
and I'm sympathetic to
we
that.
got
Mr. Chair, so
42 minutes and more bills. So go ahead.
So what are the affirmative defenses then under this bill?
Well, so this says tortious conduct, so it could be, if it's like a negligent claim, it could be the contributory negligent, it could be any other mitigation of damages. There's any number of risks, but
Consent.
it could be consent.
But Mr. Chair,
It could be factual.
Mr. Chair, then, but it goes back to my original question. There doesn't have to be any negligence in hiring of this person.
Completely different, Mr. Chairman, Senator Peak. That's a completely different claim. And if they want to come in and say, well, golly, I had no idea that under these set of circumstances, this guy was going to go out and do whatever. I mean, that's baked into this as well. This is tighter than
Mr.
restatement.
Chairman, it does not. I do not see how that is baked in here. It says they shall be liable if their employee rapes a vulnerable person. They shall be liable.
But the reasonable foreseeability stuff which we have put in there provides it to be a jury issue of whether or not they would have expected this to occur.
Well, Mr.
And
Chairman,
again, this is only
Mr.
dealing.
Chairman, where is the reasonable foreseeability?
Yeah, Mr. Dix, I think the question he's asking is because the language about the necessity and opportunity for employers to exercise control was stricken from the bill.
I do not say anything about.
That was taken out of the amendment.
There's nothing in here about reasonable foreseeability or anything along those lines. It says shall be liable. And that's strict liability. Mr. Chairman.
Mr. Chair.
Okay, hold on. Deeds.
I would say to Senator Peake, you ought to look at lines 27 and 28 because the jury still has to figure out whether the person who is the alleged victim of this offense is a vulnerable victim.
Mr. Chairman, that's not the issue. I'm not concerned about the vulnerable
That is
victim.
the issue.
Hold on, wait. We're not going to have back and forth.
Mr.
Guys.
Chairman, the issue is the employer is being held responsible for the employee for hiring a perfectly presentable employee with no knowledge that this person's going to do that. So there's no requirement that they have overlooked something, that they didn't do a record check, or that they didn't do this, that this guy has prior assault claims.
Okay.
It's the liability for the employee, not the victim. I understand that for the victim, but there's nothing about a jury determination for the hiring of the employee, and that's my concern.
Peak, I think, by the way, the substitute that you heard articulate is now up online on LIS if you want to see the actual words, not the one in your hand.
I know, but you read it, Mr.
Yeah,
Chairman.
I did.
I've
It's
read
actually
it.
up online now. And I'll just note that on line 16, it says the tort has to occur while the employee was reasonably likely to be in contact with the vulnerable victim. So reasonably likely to be in contact. So the employer can still argue that the employee is not reasonably likely to be in contact with the victim.
Mr. Chairman.
Right, Senator Carol Foy's been on for a while in the queue. Go ahead, Carol Foy.
Thank you, Mr. Chairman. I have a question for Mrs. Dix.
Mr. Chairman, if I can.
So hold on. Well, Carol Foy had a question. Can we go with her first? She's been waiting for a while.
Right. If I can, I think we're going to maybe do a little bit of discussion about this language, if we could just take it by temporarily.
Okay, why don't we do that while you guys work on language?
Thank you.
Okay, by temporarily.
I can still do my next bill, though.
Do your next bill. 901, it's an easy one, right?
Yeah, the next one, knock on wood. The next one is a little less exciting. Senate Bill 901.
Go ahead.
This is a bill that is an Indigent Defense Commission bill that came out of the recommendation there. Should be a quick fix. The way the code is currently laid out, it provides for essentially different payment for court-appointed counsel versus public defender representation. And so this just seeks to fix that language to make sure that whether you're court-appointed counsel